The extension of interim order.
Yes. When it is expiring. When it is expiring.
I am also.
Extension of interim orders, please hand over the slip. Please wait. Extension of interim order, please hand over the slip.
Extension.
My lord, I am mentioning this matter. I am mentioning for the 15th.
Please wait. Inclusion for motions, please hand over the slip. Motions only. Please wait, madam. You are for motion, inclusion. Please wait.
Motion.
Please wait. Upgradation. Upgradation. Please hand over the slip. Motions only. Upgradation of motions.
My lord, tomorrow is the date fixed before the learned trial court bill. Tomorrow is the date fixed before the
Disposal, my lord.
Please indicate that. Please hand.
Posted in first week of September. That is the most difficulty. But this matter in trial court is posted in first week of September.
For what?
My lord, there is an injunction which the other side is enjoying. Two sisters, and my client is a OCI holder. Is an American.
What is the order you have challenged?
My lord, I have not challenged, but they are not hearing the matter for 1 year, 1.5 years.
Hand over the slip.
97, my lord.
Upgradation, please hand over.
This is expeditious disposal.
What is the impugned order?
We have given 10,000 rupees and said that if not paid, appeal will be dismissed.
Hand over the slip. Please hand over the slip. Upgradation.
One matter. But in this matter, your lordship find 28,70,000 due of a wife. Chief man, husband, one after another proceeding, filing over here. They are not pursuing the matter.
Lordship, the execution is pending today. We have been mentioning since last week, but the matter is
Please hand over the slip.
upgradation. Lordship, your lordship.
Matters which have been mentioned earlier, upgradation, those matters, unless those are completed,
Lordship,
please,
the execution is pending.
yes, please hand over the slip.
Lordship.
My lord, is kindly be permitted to mention one contested application for upgradation. Because of that, petitioner is a senior citizen for eviction. My lord, suit is at
There is
the
a bench for contested application.
for evidence at the
There is a bench for contested application, hearing matters. Why don't you mention before that bench?
matter is appearing before your lordship. My lord. Matter is
Hand over the slip.
Your lordship may have indulgence to mention item number 1147 of August monthly list. What has happened, your lordship? The appellant has obtained an interim stay from this honorable court, taking thereby staying the demolition order passed by the South Dum municipality of the illegal construction. Taking the guard of that interim order, they are continuing with their illegal construction. I have already filed CAN 2 for vacating of the interim application. I am praying for urgent hearing, your lordship.
Please hand over the slip.
এটা urgent hearing এর জন্য।
Ordering time have to be protected. On that ground, there are to remove and some copy out of the order. I think the
Hand over the slip.
Milord, there is an urgent hearing actually. This was posted for further hearing. Actually, it was heard last 1 year before. Now the next day.
Hand over the slip.
27, sir. Urgent hearing.
to mention the item number 18.
Hand over the slip. Yes. Yes.
My lord, extension of interim order.
Lordship for inclusion under heading assignment.
Yes.
My lord, in this matter, they have applied for today extension. 31st is going to be expired. My lord, they suppress the fact that 7 lakhs rupees is due toward the area of rent.
Hand over the slip. Please indicate when it is expiring.
31st.
Yes.
I was mentioning item number 54 of the day's list.
Yes.
Milord, it is appearing as Milord new motion 2 under the heading new motion 2.
Yes. Yes.
Milord, the order under challenge, Milord, in a section 24 proceedings passed by the Milord, filed before the learned court below it.
24 of Code of Civil Procedure.
Yes. my lord, for transfer to a different bench in Alipur court. My lord, the learned district judge has been pleased to reject my application, my lord. Now, that is the next date before the court below is 31st of
For
August.
what?
My lord, for taking evidence. In our Act 8 case, my lord, this is interstate.
Wait, hand over the slip.
My lord, what I am humbly beseeching your lordship, my lord, if it can be accommodated any day, my lord, prior to 31st.
Please hand over the slip. Yes. 1990 supplementary list. Yes, daily supplementary list. Yes. Hand over the slip. Yes.
Consumer case filed against the personally against the managing director of Birla Opus Paint. So, the commissioner has been appointed. Commissioner has directed me to personally appear to your lordship on the 31st of August.
And for the
urgent listing.
Yes.
My lord,
Urgent listing means
It is filed, item number 19.
when have you filed?
It has been filed. It is running at item number 19 and 104. On the last occasion, opposite parties have taken adjournment on two repeated occasions. 31st of August, I am supposed to come down from Bombay to contest this personally. Consumer.
All right, hand over the slip.
Kindly consider.
May
Yes.
permitted to mention. This matter is running in the monthly list of August 2026 as item number 931.
Please indicate the urgency. Hand over the slip.
My lord, may I permit to mention one matter for extension of interim order?
Permitted to mention a matter for correction in the
Hand over the slip.
They are the lordship's kindly to mention this limitation of application which your lordship had heard, but thereafter it's running as a new motion, but it's not there in the list today, but or in the monthly list, but it's running as a new motion. But Honorable Justice
But they can-
was not there.
But they can-
Your lordship had heard it.
Yes.
Mentioning about notice, the urgency is that but in a Section 8 application of the Arbitration Act, my suit was dismissed. And now they are taking steps to create third party.
Yes.
Kindly upon
Yes.
also giving a copy of the last.
Hand over the slip. Hand over the slip. Yes.
So data leakage.
In that trust matter, from the trust, the sale is supposed to happen on Thursday.
Hand over the
My
slip.
lord, without granting adjournment, the Line Trial Court closed the defense witness and argument on behalf of the defendant. And the next date is fixed on 3rd September 2026.
Hand over the slip.
No, I am mentioning,
Yes. Sir.
no, I am mentioning one matter. This matter was fixed by the earlier mentioned on 20th July. Thereafter, I mentioned for your lordship. Then your lordship went to circuit bench. This matter was not issued.
Hand over the slip.
Item 129 of the day says, 31st is the date for final argument.
All right. Hand over the slip.
May I be permitted to?
Yes. Please hand over the slip. Indicate the urgency.
Lordship, urgent inclusion for, Lordship, urgent inclusion, Lordship, for, it is a contested application.
Contested
Lordship, it's
application.
an urgent, Lordship, is it urgent because
Contested application. There is a bench for hearing. Please move there.
927 of the combined.
Upgradation. Please hand over the slip.
I have your lordship's kind leave to mention on matter, my lord, with regard to it. An appeal, an order of injunction has been passed in an appeal without considering there was no order of injunction in the entire duration of the suit. An extension.
My lord, extends.
New motion.
Yes.
My lord, extension of interim order.
Extension of interim. Please hand over the slip.
mention a matter for correction of the order.
Correction. Please.
My lord, I am praying for upgradation.
Upgradations. Please hand over the slip mentioning the urgency.
Center. Upgradation.
Hand over the slip. Yes.
Hand over the slip to the Sagvachar.
So, Bhag, all matters are extremely urgent. So, and that's throughout West Bengal. So,
application is take out for it.
everybody has urgency. Everybody has urgency. You have seen. Yes.
By the clock.
Please hand over the slip.
This item 2108 by the clock. I will not take more than a minute.
only one line added in the by way of
That's for
amendment.
you, not for me,
No,
Mr.
no, only one line added. After trial has commenced, amendment has been allowed in the written statement. My suit on my petition is stayed. No, kindly, my lord, it's one line added in the written statement for which the suit has been stayed.
All right.
No, lord,
Please hand
kindly,
over.
my suit for
Application,
written
hand over
statement.
the slip, Mr.
No,
Gupta.
lord, kindly,
Yes.
kindly keep it on.
What do you want? Upgradation? Inclusion motion? Motion or contested application? Motion, please hand over the slip. Yes.
My lord, this is the method, section 47 rejected by the learned court below. Section 47 rejected by the learned court. And thereafter I filed a favorable revision application. Honorable court allowed my application.
What do you want? Upgradation?
No, lordship. For inclusion and also stay because learned court.
Motion, motion.
Lordship.
Motion or contested
Motion,
application?
motion.
Hand over the
Lordship. And this is urgent urgency that is learned court below fixed 5th September for process of a
That
report.
is
Lordship.
not, it will be added. Yes.
Lordship, get one.
For expeditious disposal upgradation.
Yes.
Item number 182 of today's list, my lord. My lord, the urgency is this, my lord, my section 151 application has been rejected, my lord, for
151 for what?
not for recalling of the order, my lord, ex parte order was passed, my lord, the next date is, my lord, tomorrow, my lord. Well,
Hand over the slip. Yes.
That is also.
Yes. 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 That will be taken up. Yes. Please hand over the slip.
Expeditious disposal for upgradation.
Upgradations, please hand over the slip. Indicate the urgency. Yes.
My application has extensively heard on 17th. Lordship is directed. Lordship, because the minor has lost his passport, my renewal has not been done. He is not able to take his report from the.
All right. Hand over the slip. Yes.
Lordship would kindly, any extensively heard, we have given notice to the other side also.
Please hand over the slip. Yes, madam.
My lord, I am here for upgradation of the matter.
Yes.
My lord, item 93 of today's list, daily list. While he lost order, your lordship had directed service of notice upon the other side since no other side was appearing. Service complied, service is ready. Interim order of stay is
Hand over
ending
the
this
slip.
month. Kindly takes up.
Hand over the slip.
Look, I be permitted to mention, item number 870 of the monthly list of August. This is an
Upgradation.
application for expeditious hearing.
Hand over the slip.
ব্যবসাকে স্টে অর্ডারটা চেয়েছে শিয়ালদা কোর্টের জাজ অলরেডি পিটিশন সাবমিট করে দিয়েছে নৌসাদ্য গুপ্তা মার্চ মাসে
Yes, slip hand over.
My lord, I am appearing in person.
Yes.
Cancer patient appearing in person.
Yes.
Item number 224, 225 of monthly list.
Yes.
Upgradation.
Please hand over the slip. Please supply the slip. Yes.
Slip I will hand over by day.
Yes.
In day, okay.
Yes.
My lord.
Item number 1, who is appearing?
One mentioning, my lord.
Yes.
My lord, item number 74 of your lordship's list, relating to visitation. My lord, if you allow, I'm praying for an upgradation.
Please hand over the slip. Yes. Item number 1, who is appearing? Since I am not inclined to take up this. Please, mentioning is over. Call the next matter.
Lord, I appear.
অনেক করেছে বা ওদিকে যাও
Lord, I appear on behalf of the award taker.
Yes.
It is mentioned at the behest of my learned senior friends. Lord, for hearing, Lord, your lordships had heard
Oh,
Mr.
not for
Banerjee
hearing.
of hearing on behalf of the award holder.
So both you are appearing for whom?
I am for the my lord, the decree holder.
Yes. Opposite party.
অর্ডার গুলো দাও
Opposite
তুমি
party
খেলা
award
করছো
holder.
ইয়ার কি হচ্ছে
Lord, we
ছোট
were
ছোট অর্ডার গুলো দাও
advancing on the section 47.
Yes.
Had concluded, Mr. Singh, Lord, my leader, he had argued, Lord, completed. Mr. Banerjee was appearing on that day for the award.
ওই যে
holder.
বেঞ্চ
And,
ফেরিংয়ে
Lord,
নোটিশটা দাও
he was heard but not
ডেটটা দাও
Lord, thereafter, the matter has come up before the learned commercial court at Calcutta. Lord, in terms of your lordship's order, when the matter came up, Lord, we had prayed for adjournment. Of course, Lord, there was objection on their side. Lord, now the matter has been put on August 28th, 2026.
August 28.
Yes.
May I just indicate one thing?
Yes.
Well, there are two Supreme Court orders.
Yes.
There are several others as well. Well, this is a 22 years of litigation. Finally, we've got the award. The award for recovery of possession has been affirmed till the Supreme Court. Now starts, as your lordship knows, now starts the third party applications, section 47. Now comes one other order 21, rule 29, another suit. Well, this has been going on for
So all provisions of the Code of Civil Procedure has been invoked.
no, everything. No, my lord, your lordship,
all provisions of the Civil Procedure Codes are involved in this.
everything has been exhausted also, my lord. Now, my lord, on the last occasion on 17th of July, your lordship had given them liberty to pray for an adjournment. Your lordship is aware, my lord, how liberties are being, my lord.
Yes.
Now, my lord, I'll just show your lordship only one order of the Supreme Court. I'll just give you, lordship. But kindly consider this order of the last order of the Supreme Court, which was passed on 25th of May 2026. 25th of May, 29th May.
4 months execution.
And my lord,
yes.
Well, only one moment. Kindly have a look at this judgment of the Supreme Order of the Supreme. This is when the award went up for challenge, 34 set aside, division main 37 set aside, then Supreme Court. So they were directed to deposit 25 crores. And 90 crores is my mean profit as on date. 90 crores.
Yes.
Not one single penny has been paid. This is the present situation. Now the rest I leave it to your lordship.
How much time you will take, Mr. Bose? How much time you will take?
10 minutes.
Only 10 minutes?
10. Not a minute more than 10 minutes.
But we are for the award data, Lord, we were.
You have concluded your argument.
Yes, we had concluded.
Yes.
We filed a section 8 of the benefit of that where the total amount of the deed was 2,29,500, where we made out an allegation that there was a fake transaction, one check was being given for State Bank of India, that was never been encashed, and it was an inflated deed. Thereafter, in that application, we filed upon another application for court to determine what should be the amount.
But
Obviously, that is before the larger bench also, Your Lordship.
what is larger bench?
But that is a larger bench that was already, the conclusion has been done, Madam. All the hearing has been concluded on 18th of August. That issue of in regard to the deed which are inflated by us, that should be my application under section 8 was that, Malad, where I stated at page number 22, my prayer is there, which states out, let the court determine what should be the amount, Malad. I had asked for
Here the preemption was sought for on what ground?
because I am the co-owner, my lord, undivided property, my lord. I have
Yes.
45% of the land, my lord. At page number, what the application I made out in a section 22, my lord, it starts from page number 21, my lord.
The,
Where
la-
is page number
the larger bench decision has come.
my lord, it has the final conclusion has taken from the 18th of August. The final hearing has taken, it's been reserved now, my lord. I give out the judgment, my lord. It can be taken, my lord. The last hearing that took down on 18th of August, my lord. Till then, my lord, let it be taken. Thereafter, my lord, it would be much better, my lord.
Uh,
The general campaign of cooking that benefits the son. The assistant very high, higher subject. But the paragraph 22 of my lordship order. Chief in terms of national health. Yeah, that's what the higher subject. What type? Higher subject as per the presentation of cooking.
it has been submitted by the learned advocate for the petitioner. matter. Grateful. Who appeared? Have you served upon him? Urmishta Ghosh Sharma was appearing.
22nd December. Joydeep Bhattacharya, CO 940,
Yes, 940.
22nd December of
22nd December 2025.
requested me to serve the copy of the application.
Joydeep Bhattacharya.
I have served it. This is the service upon his. He requested me to serve me a copy of the gift application. I served it immediately. He appeared.
Mr. Ghosh.
My lord, this is my petition, my lord. Orders first and February 2025. Proceeding under order 21 rule 97 1 initiated by the third party registered to an execution proceedings arising out of a partition suit
Yes.
at 48 of 1994. In that, my lord,
You are appearing for
Yes,
the
my lord,
opposite
for
party.
the opposite party. My lord, what has happened over here with my senior over here? The suit was initiated on the last day. What my lord was asking was whether the exhibit was already there in the original suit or not. My lord, I failed on the last occasion not to show it, but I have it today. This was marked as Exhibit A1, the document. They are independent. They are claiming to be. Okay, let them finish, my lord.
So,
Then I
Mr. Mukherjee, what was the point on which it was admitted?
petitional application. In the execution.
Application filed by the petitioner for tendering the certified copy of the deeds of 1967 stood rejected. So, were these marked as exhibits?
This was already marked as an exhibit in the suit.
Yes.
Yes.
This case arises out of from the title execution case number. Order 21 rule 97 that execution arises out of a partition. My point is that I have purchased the property from one of the party in the partition suit who had purchased it from my learned friend's co-sharer way back in 1967. Issue had been framed in that suit that whether this particular deed is void or not. That issue has been decided in favor of the defendant from whom I have purchased. That deed is valid. That has been decided in the preliminary was passed. Second point is, in that preliminary decree, the total area was held partiable is 2.17 acres. The final decree, it has gone as 2.70.
No, that's a different point altogether. By this impugned order, that application for tendering the certified copy stood rejected.
Yes.
If the original is already marked as an exhibit,
Not there.
he's saying
is
that.
there.
Please check up that.
No,
Those
my lord, my lord takes up.
Second application is
My lord is.
my second application was to keep the records of the original partition suit under order.
That's a different thing altogether.
Where
But
it has been,
Where
it has been rejected.
no, but are you disputing that these deeds are marked as exhibits in that suit?
My lord,
I'm asking you because on that point,
my lord comes at page number. My lord comes at page number.
he's producing that document. Please see that.
My lord comes at page number 83.
So Mukherjee, please see that.
my lord, if
Are you disputing that those documents? He's
It is his.
Please give a copy.
It is his application I am showing it from. Page number 83.
Yes, it has been exhibited. But
I am not even producing a document independently over here. It is his document.
21, Rule 97,
Page number 83, second para.
It is a the code in itself. So if this document is not marked in this particular proceedings, will the learned executive court look into that document at all? Will it be obliged to look? It has been marked as X and X by 1 for identification. Kindly please
My lord, the second para and page number 83.
let my learned friend come.
No.
Then I will make the argument. Lordship kindly comes to page number. Lordship kindly comes to 238. There is no bar in marking this document here in this proceedings. Lordship, may kindly see page.
Yes, if those deeds are already marked as exhibits in the suit, so what difficulty you have with the certified copies are marked as exhibits? Why are you opposing that?
My lord, the only thing is
there will be no difficulty. The original deeds have been marked. The certified copy can be marked as an exhibit.
I bow down to that, my lord. The only
Are you opposing that?
I definitely oppose that. The only one thing is
Ashun, the entry. Seven. Yes.
এটা নিন তো।
None appears for the petitioner.
Mr. Mitra is appearing on behalf of the opposite part. My lord, the application has been filed, my lord, out of time, my lord. The application for extension of interim order has been filed out of time, my lord.
What is the impugned order?
In isolation of the my lord, their suit was dismissed.
How can that application be taken up for hearing in isolation with the hearing of the appeal?
My lord, that their suit was dismissed, my lord, because they could not produce any documents. They were in position, my lord. They are trying to fill up that lacuna, my lord, in appeal stage, my lord.
This application has to be heard along with the hearing of the appeal.
What I on, my lord, Mr. Mitra is appearing, my lord. Kindly file lordship, Mr. Anirban Mitra is appearing for the opposite party, my lord.
Who is appearing?
Mr. Anirban Mitra.
Yes. Ask him to come.
My lord, my lord.
Pass over.
Pass over.
Ask him to come. Yes. Next.
So I am for the opposite parties.
Interim order, not passed by, not had expired on November 2025.
Yes.
July 26. Service.
So
Yes.
see, from the application, I find there is no ground why this honorable court would reimpose the order, because the order passed by your lordship expired in November 2025. Lordship, kindly come to the
November
contents of the
2025.
application. And this is suit of 2012.
What is the impugned order?
Order, my application for amendment of the written statement has been rejected and my right to lead evidence has been closed.
Right to lead evidence has been closed. Why?
PW has been closed. The issue, the situation of the suit was that PW1 has completed and concluded the evidence. Thereafter, I was to lead evidence. At that junction, I took out an application for amendment.
You did not cross-examine PW1.
Yes, that was going on, that was completed and then concluded. I filed this application thereafter prior to leading my evidence. At that stage, Lord, my application has been rejected and, Lord, also my evidence has been. The suit is, Lord, for a declaration that I am not a tenant. One of the reliefs, I am not a tenant. There, my lord, I want to introduce a document whereby, my lord, I
Yes. Where is the written statement?
It's a written statement 31 onwards.
And where is the application?
Application 43.
add to that kindly takes the place.
Please give me 1 minute.
Lord, kindly comes to the plain ones.
Yes.
Lord, kindly comes to page 23.
23.
The degree for declaration of the dependents are neither the owners nor the tenants. So, Lord, he presumes that there is some kind of Lord claim with respect to tenancy. That's one. Lord, thereafter kindly Lord comes to my application at page 43, paragraph number 5 at page 44. Lord, specifically stated the
Paragraph number 5.
5 at page 44.
I've specifically stated why I was not in a position to Lord annex this particular document at the time of filing the written statement. Now, prior to my evidence being started, I found this document which is very relevant. Lord Ashok Kumar Rai not in dispute that he is a co-owner. Lord, I've given the power of attorney also, that by virtue of that power of attorney, I was inducted as a tenant. Now, Lord, whether I am a tenant or not through that power of attorney, that's the subject matter of the suit. Here the court comes to the finding that I have not given any reason why I was not making this application belatedly. It kindly comes to the interim order.
Yes.
Nowhere in the but this is in terms of page number 2 of the third perused record.
Yes.
This is a suit for such a declaration as owners of the landlords of the suit property for declaration that the plaintiff dependent declaration that the defendants are not tenants. Whole thing. Nowhere in the WS as such defendants stated that they were tenants. At paragraph number 11, Sajjana, goes on. This is my first objection. The plaintiff says that he is not sure whether I am a tenant or not. He wants a declaration. Now, Lord, kindly comes to record review issue frame. Now, Lord, whatever has been done, it has been held. The application was allowed on 15th July 2024, and again case started running DW. Today, the case was fixed for such and such. There is no rent receipt by the defendant has contemplated. The application is benefited to delay the proceeding. And Lord, the other one is, Lord, there is no valid ground given that why defendant took so much time to pray seeking the amendment. Specific ground I have made out.
Yes.
No, Lordship, this is the amendment which the defendant sought to incorporate. This is not a new fact. I could have understood that he trace out the power of attorney as it has been alleged in the amendment application at a later stage. Lordship has gone through the written statement. There is no averment to that effect that I was inducted as a tenant by such and such person in view of a power of attorney. There are no pleadings. I have gone through the written statement. A new fact was tried to incorporate. The written statement was filed in 2015 and 2024. This new plea was absolutely new plea, and the Honorable and the learned trial court has rightly rejected because there are no pleadings to that effect in the written statement. The learned trial court rightly concluded that there are no pleadings that he is a tenant.
This application was filed when?
In 2024.
No. What is the date?
From the
What is the date of filing this application?
It might be in 2024. But in the copy, it is not.
Defendant filed petition
mentioned.
Under. Is it on 21/5? No. Because objection has also been filed. Written objection has been filed. But so you filed that on 21st of May 2025. It appears to be so. No, cannot be. Because it records defendant's file 21/5/2025. And when your evidence was closed?
But my evidence was closed on that date, sir. By virtue of the order in June, the last line, no DW closed.
Recalling the closure of PW1.
Yes. Look, the evidence of PW1 was going on. I was cross-examining.
Yes.
That juncture, my lord, I came up with this document. Lord, I wanted the PW1 to be recalled because it was closed on an earlier occasion. That was denied. Now, my lord, with that, this application and my right to, my lord, depose also.
What can be done? You took several adjournments. It was closed on, PW was closed on 5th of October 2023, and we have filed the amendment application in 2025. What can be done?
Not only that, the pleadings which they now to
Rightly close to your evidence.
there was no pleadings to that effect in the written statement.
When I came for Milord, I got this document, then only I filed this application.
So for that, you are entitled to pray for adjournment, and the court will sit tight.
Second, saying, Milord, I am entitled for an adjournment. But what I am indicating is this document was not available with me. Lord, in a situation, this document was available with me at an appellate stage. That case also I could have relied on this. The only question is, Lord, the relevance of this document. Lord, kindly see what this document is doing.
Yes, Ashul, this application under this application Yes, where is the other matter? Dakun.
My lord.
Passover matter, Passover
Yes,
data.
your lordship has been kind to my lord.
Yes.
My lord,
Yes.
if
Order
you-
41 Rule 27, how can it be taken up in isolation with the hearing of the appeal?
not isolation, my lord, subject to correction, my lord, affidavits are exchanged between the parties and it was heard, my
Appeal
lord.
has been disposed of.
No,
So, how can Order 41 Rule 27 be decided in isolation with the hearing of the appeal? Whether these documents are necessary cannot be decided in isolation.
absolutely, my lord. Absolutely, your lordship remembers has passed a similar order in another matter.
So, I'm
It
setting
can be
aside
heard
this.
at the time
I'm
of
setting
hearing.
aside this, directing the Order
My
41.
lord, with your
Asun,
pleasure, 9th
this-
September is the date before the.
Asun. Yes.
My application was under 71 and 72 was rejected. On the ground, I have not paid any admitted amount. It was the contention of the wall of the garden. My contention was there was no admitted him. The entire the rent was paid by the dependent by
No, you have paid the entirety.
Yes, yes,
There was no default.
no default.
Then
Kindly comes to your lordship's order dated 1st of September. I'll take 2 minutes. 1st of September 2025.
yes.
Say there's a substance in the argument, my lord. I'll just read the grounds. Rejected the application under 7172 of the 1997 Act when the petitioner deposited the rent for the month of May 2024 immediately after appearance in the said suit. Now, my lord, kindly comes to the order impugned for once. These are all matters of record. I'm not, my lord, kindly takes up paragraph 4. And in the petition under section 7(1) of the Premises Tenancy Act, the defendant stated that they were defaulters in respect of the payment of
Impugned
rent.
order. Impugned order is 1st of August.
Impugned order is 1st of August.
Yes.
Before this court on 7th of May 2000, now defendants after receiving summons on 1st of May appeared before this court on 7th of May 2024 and filed the instant petition. By virtue of this petition, the defendants are praying to deposit the rent of the month of May 2024. And now, when does he actually pay the rent? Current. My lord, kindly comes to the rent receipts, rather the challans. My lord will find that, my lord, it's probably with the page 42. He appears in May, files an application, deposits the current rate of rent of May, June, July, August in August.
Where is that?
Page 42. There, my lord will find that is a challan for the rent for the month of May 2024, 450 rupees.
Yes, that is on 9th of August.
9th of August. He appears in May.
Yes, Mr. Chaudhary.
Before that,
What? No.
My lord, the order, my lord, one more thing I'll record, but there's an order recording that they have paid this rent in. My lord will kindly see order dated. That order is also before your lordship, my lord. Order dated 9th of August 2024, order number 7. My lord, there's no pagination, my lord. And it's
9th of August.
9th of August, order dated 7.
7th of August.
7th of August.
Yes.
The record is put up today as per prayer of the defendant number.
Yes, for
1 of
May
May.
to August.
Yes. For the first time, he deposits challan.
It's out of time.
It's out of time.
But before that, the challan was filed, that was kept in the.
Where is that case made out? Where is that case made out?
That was the.
No, you said that you paid in May.
But
That's not the payment in May.
Yes, my lord. The subsequently, that was accepted, my lord.
That is cannot be a ground.
Kindly have time, my lord.
There is a challan. The date is mentioned 9th of August, and the court allowed at the risk of the.
Yes. On that date itself.
On the date itself, the challan was issued. On page 42, at the bottom left portion, 9th of August 2024. The challan was first time issued on that date.
Along with tenders challans towards house rent. So you have tendered on 7th of August and it was deposited on 9th of August.
9th of August.
Yes. Asun, this application under.
Subsequently, my lord, the challan was accepted, my lord, and my lord, the deposit.
Sir, the initial deposit is wrong. What can be done?
My lord, then my lord, thereafter, my lord, the 7.1 and 7.2, my lord, the hearing of that application has been fixed, my lord, my lord, the court, the lauded court below, my lord.
Yes.
That is not within my knowledge either, my lord.
For hearing 14th of August 2026.
Yes,
How can it be fixed for hearing?
On 14th August 2026, my lord, fixed for all.
No, how can it be after rejection?
They're against the order of rejection itself.
You have come up against the order of rejection. That I do not know. This application under Article 2 Yes.
That matter of first point of law is involved, whether the time period fixed by the honorable division bench for filing the written objection to the injunction application can be extended by the learned trial court. On the last occasion, my lord had asked me to search for a judgment. My lord, I've got one judgment of the honorable Supreme Court. My lord, for the proposition under para 21, that the parties in default is required to make out a case to the satisfaction of the court who has fixed the time, so that 148 could be, my lord, para 21. My lord, here in this case, neither, my lord, the learned trial court,
Paragraph 21.
para 21, internal page 7. May I please? It is not. The power to fix the time for doing of an act must, in our opinion, carry with it the power to extend such period, depending upon whether the party in default make out a case to the satisfaction of the court who has fixed the time.
Please give me a minute.
Take off, sir. Here it goes. Citation AIR 2010 Supreme Court 3.
Where is that which has been said that it has to be before that court? Which
Yes,
paragraph?
sir, para 21. May I please, bro?
Yes.
It is not in the light of the above decision, as my lord got that,
Yes.
open to the respondent to argue that a court can fix time for doing of an act like making of deposit in the instant case, but has no jurisdiction to extend the said period, even when a case for such extension is clearly made out. The power to fix a time for doing of an act must, in our opinion, carry with it the power to extend such period, depending upon whether the party in default makes out a case to the satisfaction of the court who has fixed the time. But there is also one.
Is now where what has been done here?
But in this case, my lord, ad interim order of injunction was refused, my lord. The plaintiff had moved the honorable division bench against the refusal of the grant of ad interim order of injunction. The honorable division bench, my lord, by passing order dated 17th February 2025, had granted an order of injunction and granted liberty.
So what happened here?
Lord,
What is
here-
the impugned order?
In this impugned order, my lord, there was a direction by the honorable division bench upon my learned friend's client to file written objection to the injunction within 3 weeks. The period of that 3 weeks had got expired on 10th of March 2025. On 20th March 2025, my lord, by way of put up application, the petitioner plaintiff, before your lordship, had presented an application.
Oh, the trial judge extended the time to file.
My lord, has got no.
This cannot be done.
In the only one liberty that I can approach that appeal.
Yes.
So if that liberty, if that observation is given by your lordship, my lord,
That has to be done.
my lord, but
So particularly that has to be done.
my lord, that
That's
limit-
as per this, that liberty has to be done.
My lord, just one
Mr. Patwari, that will be again delaying. If you are very serious in that, then the
No,
liberty
only one submission, my lord, accept it or reject it. The order was passed on 17th February 2025. They have not taken within 30 days.
All
An
right, all right.
application is required.
This application call the next matter. Yes.
My application suit filed by an unregistered society against me. And suit was dismissed on the ground because none of the members are not there. No leave has been obtained under order on too late for suing me, my lord. And against that, they prefer the money appeal, money should well. And in money appeal, they filed the amendment application. By that amendment, my lord, all parties have been allowed to be bring to the appeal. Last order, your lordship kindly says.
Yes, you are appearing.
Yes, your lordship, I'm appearing for the opposite party.
Yes. So I'm extending the interim order. I'm after hearing the learned advocates for the parties.
Hearing be given.
13 yes.
Evidence has been kept in the record.
My lord, I am appearing for the petitioner, Mrs. Riya Vallabh, today not well for.
Yes.
So next
Yes, yes.
date-
How are you agreed by this order? How are you agreed by this order?
I am not instruct the full details.
Who is the advocate on record?
Riya Vallabh, Mrs. Riya Vallabh.
Where is he?
Not well, he's at home.
An accommodation has been sought for on the ground of the learned advocate.
Judgment debtor petition. The suit for execution of licensee. But suit was decreed. But I prepared an appeal. In the appeal, I filed an application for stay of operation. The learned trial court granted me occupational charges of ₹10,000. I filed an application that for exemption of that money we could not have.
Exemption, you need not pay anything.
10,000 has been ordered. I filed an application for reduction of that.
Reduction.
Sorry,
I saw the
reduction.
exemption. Yes.
It was reduced to 6,000. I filed another application.
Again to reduce, to make it zero.
No. But on two-fold count. Firstly, the property which is they sought for license, the eviction of licensing is a statues house, a mud house, firstly. And secondly, if the suit itself, when they paid for
It's not maintainable.
it's paid for a means profit, they paid ₹5 per day. No matter if it is considered
These issues are settled, Mr. Ghosh.
It should be,
These issues are already settled.
it should be 1,500 or like 2,000, but it should not be 6,000 on that. But
If you cannot pay, Mr. Ghosh,
I can pay, I will pay, but the amount is much excessive.
yes. If you cannot pay, please vacate.
I
144 is there. Succeed in the appeal, please come back.
I pay, well, I'm only paying for reduction, nothing more. Nothing
No
more.
further reduction. It was
Well,
reduced once.
just two pages. I'll just for my satisfaction. If you'll
Yes.
kindly come to page 14. The plain, the prayer in the plain, page 14.
Yes.
I've got it. But kindly see the prayer 2. For a
Prayer
degree of damage at the ₹5 per day.
Mr.
in the-
Ghosh,
But it's
we
the-
succeeded, I am telling you. We succeeded before the Honorable Division Bench presided over by Justice Bhaskar Bhattacharya on this ground.
No.
But I'm telling you, please allow me to say. So that was the ground. This was fixed, not more than that. That has been set aside thereafter.
No, but it's
So-
not kindly tied at the trial court to
It's
fix it.
good that you have placed it
Well,
before
landed
me.
trial court
So
without considering anything. This is simply an order.
I made that argument, it was accepted, but later on differently.
No, but kindly
now-
consider that the amount is, well, 6,000 is a mud house.
Please vacate, get it, succeed in the appeal, please
No, but
come
you
back.
should also see that.
You need not pay,
the-
Mr.
What is the
Ghosh.
matter is that the properties belongs to me. I sold it to my cousin brother. But he allowed me to stay in a mud house. No, but I am staying, now he filed a recovery of license.
The submission which you are making, it reminds me of an incident. I have an experience of that. That is what I am telling you. This
But
application,
kindly only on the point of.
you need not pay, Mr. Ghosh.
I pay, my lord, I'm always ready to pay. But
How
the-
much? 1,500.
No, my lord, but like let it be certain, my lord, 6,000 has been fixed. But for
But what is the,
mud
what
house,
is the certain amount? What is the certain amount?
2,000, 2,500, but kindly consider 6,000.
You are not doing charity, Mr. Ghosh.
I'm not charity,
Mr.
man.
Ghosh, you
Kindly
need not pay.
consider the amount.
In the similar,
Village,
you
in
can
a
get a
village-
better, Mr. Ghosh, you can get a better accommodation at less than 6,000. Please
But
move
this
to
is-
that
this is-
accommodation.
Kindly consider this is a
Let
village
the-
area. It's a
let the
completely a
plaintiff-
village area.
Yes, that is what I am telling you. You will be getting a better accommodation in a better locality,
But kindly,
please
kindly
shift it
consider
to
this
there.
aspect. But,
You need not pay 6,000.
but kindly consider this aspect because
Yes,
it's a
what do you
village
say?
area. But,
You are, oh, where is the other side?
but it's first time.
This application under Article 227 of the I'm coming after 5 minutes.
And item number 7, which is to go out of list, my lord, extension of interim order. My lord, interim order till 31st August, my lord. Your lordship kindly on the other day.
What can be done? None of
Because,
your
my lord,
present.
coming to your lordship's court, but at the time of call, it has
7 টা রাখুন। All right. Yes, please wait. Yes. 14.
Item 15, my lord, this is my application for expeditious disposal of a misappeal, my lord. I am the appellant, my lord.
Expeditious disposal of
a miscellaneous appeal, my lord. I am the appellant.
miscellaneous appeal arises out of what?
My lord, the suit was decreed ex parte in my favor, my lord. Subsequently, the opposite party filed an
Order 9, Rule 13.
Order 9, Rule 13. In respect of that, a stay order was obtained, my lord. That I challenge by way of this misappeal, my lord. My lord,
Order 9, Rule 13 dismissed.
Order 9, Rule 13 was pending, in which they obtained an ad interim order of stay, my lord. In respect of that, I preferred the misappeal.
How the miscellaneous appeal is maintainable against an order of stay?
My lord, kindly sees the order. When the appeal was admitted, I have annexed the entire order sheet.
How that is an appellable order?
It has been heard, my lord. Kindly sees the order dated 14th of June 2022 in the order sheet.
This application under Article 227.
My lord, I am appearing on behalf of the husband petitioner, suit for divorce filed by the husband. My lord, this divisional application is against the order passed in an application under section 24 of the Hindu Marriage Act.
Yes.
My lord, the wife filed an application.
You are the husband.
I am for the husband. Wife
Yes.
filed an application under section 24 of the Hindu Marriage Act, and the learned court below passed an order directing the husband petitioner to pay rupees 20,000 per month and 10,000 for litigation cost. My lord, husband is a railway employee. My lord, his gross salary, net salary, my lord, admittedly 47,425. And his, my lord, the aged mother, aged about 75 years old, is depending upon the petitioner, my lord. And if your lordship kindly come to the ordering portion for a moment, my lord.
The learned advocate appearing for the petitioner may be justified in arguing
Gratefully, Your Lordship.
This is my revisional application, the defendant's revisional application from an order rejecting order 7 rule 11 application. Kindly seize the impugned order once, my lord. It's really, my lord, quoting the provision, no reasoning whatsoever.
On what ground do you have prayed for?
But it's really illusory cause of action, clever drafting, and suppressions galore. Man, I'm backed by two.
Suppression can be decided in order 7 rule 11.
Otherwise, I would have said no, but there are two Supreme Court judges which says clever drafting and, my lord, the fact.
Clever drafting is another thing. Suppression.
Clever drafting and also, my lord, illusory cause of action, because, may I just indicate, impugned order has nothing.
Since you have said suppression, I called upon you. So other things.
Other things I am, yes.
Since you said suppression, there are suppressions. That's why.
The plaintiff has filed the suit. The plaintiff is an owner in a apartment where there are 100 flat owners. The defendant, which is before your lordship, is the association.
Please show me your order 7 rule 11 application.
Yes, ma'am. Your lordship would kindly have a look at page 260.
Page
260.
260. Order 7 rule 11 rejection application.
Because, my lord,
3 volumes.
Plaint and written statement, all those have been annexed. So, my lord,
Written statement is necessary, Mr. Gupta.
it is not, but everything was there, my lord. So,
Yes, yes. So that is the suppression you want to show from the written statement.
No.
Will not be showing.
No.
Thank you. Yes, 260.
But yes, 260.
Yes.
And if your lordship, may I show the plaint first, my lord? Very well. Your lordship will kindly see this. There's a prior suit concerning this property by the association.
Mr. Gupta, those can be decided in order 7 rule 11. Prior suit, what are the orders passed, administrative.
It's not a run-of-the-mill order 711, but your lordship would kindly permit me 2 minutes. In that suit, there is already a subsisting order. That, my lord.
So, Gupta, can that be a ground in order 7 rule 11?
I'll not take more than 2 minutes by the clock. There are 4 things which have deliberately ignored in the plaint to file the suit. Deliberately not there. So that is the illusory cause of action. Kindly permits me 2 minutes. A, there are 2 subsisting orders which grants the association the powers to disconnect the supply in the event they do not enhance the charges. B, this one. B is there is a AG annual general meeting resolution which is there in the notice board, following which the rate has been enhanced, which 99 others are paying. He has said we are collecting on the basis of illegal charges. See, my lord, the plaintiff has, my lord, ignored all of these and saying that in the plaint, the only cause of action is our demand is without any basis. So, cancel the demand. So, when everything is there in accordance with law, notice board, everything is there. So, this is, my lord, really a clever drafting, not mentioning any of these, just one-liner pleading in the plaint, and, my lord, the suit has been filed. So, my lord, here, my lord, I come in by way of, my lord, if your lordship kindly permits me to play 2 judgments. This is really clever drafting to, my lord, make this suit, my lord, maintainable. Otherwise, 9 other flat owners have no difficulty. Everybody else is paying, and I have enhanced this after 20 years from 3 rupees to 6 rupees. They are challenging this, saying I have no legal basis.
Please show me the plaint.
Yes, kindly see the plaint once. Page, your lordship would kindly have a look at page 49. Volume 1, page 49. Kindly see paragraph 3. Suddenly the plaintiff is surprised to get a notice of maintenance bill, my lord.
Yes.
And then, my lord, in paragraph 5, in our letter we have mentioned of all these orders. They say that all these are there, not annexed, nothing. Very well. Kindly then seize paragraph 9, page 51. Plaintiff has reasons to believe that the defendants are claiming maintenance charges on an imaginary basis. Everything is there. Imaginary basis. Then paragraph 12. Cannot be cut in a manner whatsoever as per the desire of the association. The memorandum of association which he has subscribed to, suppressed. Not mentioned, not even a word in that plaint. Then paragraph 15. The claim demand is without legal basis. So by all these things, he has given an impression that everything which we are claiming is just a letter where we are claiming this. Kindly seize the prayers now. at my lord, page 53. Declaration that I will not be able to claim. Declaration that my lord, this demand is bad. So, my lord, this is really, my lord. Now, your lordship would kindly permit to me to place two judgments. My lord, kindly permits me to place this 2025 SCC online SC 793, my lord. Paragraph, my lord, 4.1. Your lordship would kindly have a look at
4.1.
14.1.
14.1.
Yes, 14. Your lordship would find that page, my lord, 9. My lord.
Page
Page
9.
is at the top, my lord, top left. As your lordship got it, my lord, page number
Yes, yes.
14.1. Thus, it is clear that the above provision, that is Order 7 Rule 11, serves as a crucial filter in civil litigation, enabling courts to terminate proceedings at the threshold where the plaintiff's case, even if accepted in its entirety, fails to disclose any cause of action or is barred by law either express or by implication. The scope of Order 7 Rule 11 and the authority of the courts is well settled in law. There is a bounden duty of the court to discern and identify fictitious suit, which on the face of it would be barred, but for clever pleadings disclosing a cause of action. That it is cause of action, that is Sharia. Generally, subclauses A and D are standalone grounds, but can be raised by the defendant in a suit. However, it cannot be ruled out that under certain circumstances, clauses A and D can be mutually inclusive. For instances, where clever drafting veils the implied bar to disclose the cause of action, it then becomes the duty of the court to lift the veil and expose the bar to reject the suit at the threshold. The power to reject a plaint under this provision is not merely procedural, but substantive, aimed at preventing abuse of judicial process and to ensuring that the court's time is not wasted on fictitious claims, failing to disclose cause of action to sustain the suit or barred by law. Therefore, the appeal against such and such, then the lordship would kindly have a look at. And this was a case when Order 7 Rule 11 rejected, upheld in the High Court, but the Supreme Court rejected the plaint. Then we will kindly come to paragraph 15. Really 16. Paragraph 15 goes into the facts. You kindly have a look at paragraph 17.
Please give me a minute.
I'm sorry.
Yes,
Kindly see paragraph 17 once.
1717.
But this is, my lord, and manifestly vexatious and meritless plaint. Because, my lord, he is a party to all these 4 documents which he has deliberately surrounded and, my lord, by way of clever drafting, pleaded this case. So, my lord, there is the memorandum of association which permits that. There is the minutes of the AGM
Mr.
which
Gupta,
permits.
you have to show that from the plaint itself, not from other extraneous documents.
I understand, but in the plaint, he has mentioned of the AGM. He has not annexed. So, my lord, if your lordship kindly looks at it from, my lord, another viewpoint also, that, my lord, one pleads, but relying on the judgments that only plaint and the annexures can be seen, he will not annex that definitely. That is playing fraud on the court. So that is a vexatious and manifestly, my lord, this is meritless plaint. Because had those been on record, then the court would have definitely, my lord, not given him the declaration he's praying for.
Yes, please show from the plaint itself, it's barred under which provision? Please show me.
Cause of action. No cause of action is disclosed.
How then this judgment help you?
Because
This judgment?
Yes, my lord, because in this judgment, my lord, it says that, my lord, they are trying to, my lord, in a circuitous way, create an illusory cause of action.
On the basis of the plaint, there is a finding.
Yes, but your lordship would kindly see the plaint in this case.
4 grounds why the suit is not maintainable. Those have been indicated in sub-paragraphs of paragraph 15.
Paragraph 15, yes. So, my lord,
I've gone through that.
Yes.
So why the suit is barred? So please show me why this suit is barred or of vexation. This is not an illusory cause of action. This suit is barred on that.
But I am saying our case is an illusory cause of action.
Mr. Gupta,
From
only
the
thing,
plaint, your lordship would find.
the other things which you are trying to import cannot be imported in order 7 to 11.
No,
that's the only difficulty.
I understand. I completely bow down.
So please show me from the plaint.
Kindly sees from the plaint, he has
Yes.
pleaded the orders.
You have to, when arguing, you have to take the plaint is true and correct.
Correct. Absolutely.
Yes.
Absolutely. My
Then
lord,
show.
absolutely. My lord, I bow down. Your lordship would kindly have a look at page 51, my lord.
Yes.
My lord, this is really his cause of action, paragraph 3, receipt of the maintenance bill. In respect of that, my lord, kindly sees paragraph 5. He has mentioned of, my lord, this order on which is there in the maintenance bill. Kindly sees 28 September 1989 order. He has pleaded in paragraph 5. He has not annexed. That is one which permits that in the event an occupant or a flat owner does not pay, then the association is entitled to, my lord, disconnect. Now, your lordship would see that the association is really all the flat owners. So they are having to bear the brunt of the litigation expenses of this frivolous suit at the instance of one delinquent flat owner who refuses to pay from 6 rupees to 3 rupees to 6 rupees, whereas all others have, my lord, agreed to that. Now, my lord, kindly comes to the next page, my lord, where it's his pleading that, my lord, it's on an imaginary basis. But he is a member, he has the memorandum, he does not annex that. So if that is the case, then every matter, my lord, even if there is a deed, he is saying that no, he has no right because he has no title, nothing. So on that basis, my lord, he is really coming. Where he is not his clever drafting in a circuitous way, my lord, is illusory cause of action. So this suit, my lord, your lordship would kindly not permit this to, my lord, sustain a litigant like this, my lord.
Anything more? Ashu, this application under Urgent.
Praying for Lordship expeditious disposal of the matrimonial suit Lordship which is pending before the learned court below.
You are for the wife.
I'm for the wife Lordship. The matter is filed in the year 2023. There are Lordship 3
What
years.
is the stage of the suit?
Stage of the suit Lordship, the cross-examination Lordship, at the stage of cross-examination which is deferred by the learned counsel of the respondent Lordship several occasions. Kindly come to the Lordship page 26. I have annexed the all orders. 26 Lordship. Initially on 19/7/2023 matter filed Lordship, thereafter transferred to the first FTC first court Barrackpur Lordship. Thereafter
But the cross-examination of whom?
cross-examination of the PW1
PW1 is going on.
Lordship. They have taken time Lordship initially at the time of submission of the written statement, cost imposed
The
Lordship.
regular presiding officer is available.
Like earlier Lordship available, but 2 occasion the transferred Lordship. Now the FTC fourth court is the in charge Lordship.
Charge
Taking
court
the-
cannot decide the
Lordship,
this
over,
application. This application.
Frame a specific time period Lordship can dispose of.
The regular presiding officer is not there. This application under Article
Court
2.
Lordship already taking the evidence.
Charge court can take the evidence and dispose of the suit. This application. Yes.
Yes, my application, my lord. Suit for declaration and injunction, my lord. Suit for declaration and injunction.
Who are you?
I am for the defendant.
What is the impugned order?
If an order is my lord, I file an application under Order 7 Rule 11. Before I moved that application under Order 7 Rule 11, I took a preliminary application, my lord, that the district, but the civil judge senior division does not have pecuniary jurisdiction. As my lord, the pecuniary jurisdiction has been increased from 30 to 60,000, and the plaintiff has valued this as 30,100. My lord, after that, my lord, the judge my lord, directed the Seristadar to file a report and to see whether my lord, the court has pecuniary jurisdiction or not, and whether the court fee paid my lord is correct or not. My lord, the Seristadar has filed a report, said that the court fees is paid correct, but whether pecuniary jurisdiction is regarding concerned, he does not have any guard file to undertake to see whether the
He does not have any
guard file, my lord, to undertake to see that whether the court has pecuniary jurisdiction or not. But the court accepted that report and asked me that you could not show the notification, so my lord, you refused. You could not show the notification which I have relied, my lord. So my lord, the court said that nothing been done.
when the pecuniary limit was enhanced to 60,000 from 30,000?
But suppose 2018, my lord, I suppose. 2000, my lord, 2000.
All civil judge junior divisions were having pecuniary jurisdiction of 60,000.
No.
Are you sure?
No. Consider this judgment, my lord, that I have shown, my lord.
This judgment, my lord, passed by the
Sir,
the
only in
first-
some cases.
My lord.
In some courts, some civil judge junior divisions, by way of a notification, they are being given jurisdiction up to 60,000. Otherwise, civil judge junior division has 30,000 jurisdiction. Over and above.
Sialdah and Damon Harbor.
Yes, Alipur, some
Sialdah and
courts,
Damon Harbor.
yes, Alipur and some courts, they are having that, this is pending where?
Pending at
Parasat.
Parasat.
So
Pending at
can you
Parasat.
show that there's a specific notification with regard to Barasat court?
My lord, that my lord, I have to then.
You won't relied on judgment against him, my lord. That has been quoted there. Only Alipur, Sialdah
That
and
I have to give me 1 day time. Time.
What 1 day accommodation? And even that is not a ground under Order 7 Rule 11, can be Order 7 Rule 10.
Yes, my lord. But before moving that, my lord, if the court does not have jurisdiction, my lord, then he have to give it to.
And
Yes,
Mr.
yes, my lord.
Another thing is that below valuation can be taken, not the above valuation. So even on that count, you also fail. You also fail.
I need to yell also.
and that is not the ground also in the application.
But that application, my lord, that date had been fixed, my lord, to move. my
He
lord.
says that
But
it does
before
not
moving that
disclose
application,
any
this
cause
point
of
was
action.
taken by.
The ground in Order 7 Rule 11 can see
There are the
court-
grounds, my lord, that the court
that-
will examine well.
that the suit is bound to fail in the event of trial. Then
That
Where?
para 4, page 27.
The court has fixed another date, my lord, to hear out my order.
Cause of action to proceed, and in the absence of the same,
That is
para
not
4,
more point.
the suit is bound to fail in the event of trial. That is this ground. So
Cancellation of deed.
Cancellation of deed, my lord, the order 7 rule 11
para
application
4,
was not
kindly
there, my
see
lord.
para
Before
4
that,
of
my
the
lord,
application.
I
Order 7 Rule 11 has been fixed for hearing.
Yes, my lord, fixed for it. Let it be there, my lord. There, if I succeed, and if I don't succeed, don't succeed. But I have taken a point,
After some argument, yes.
My lord, I'm for the petitioner husband. This is
Yes.
my application challenging the order under section 36 of the Special Marriage Act, whereby the application filed by the wife praying for maintenance pendental light for the child was allowed. And I was directed to pay 30,000 rupees as maintenance and 20,000 as litigation costs. My lord will kindly come to the impugned order.
Yes.
My lord will come to para 4. It is furthermore the contention of the
What is your income?
my lord will come to page number 148. My income is from the last 2 years, my income is nothing. I am engaged in a shipping corporation where I have a contractual employment. I do not have a fixed income. When I have a job, only at that time I earn. My lord will kindly come to page 148.
After all, you have to maintain your child.
My lord,
How can you deny to
my lord,
maintain
I'm
your
not
child?
denying. I am just saying that the maintenance amount be such that I am in a position to. My wife is a working woman. She is earning. I am just praying that the maintenance amount should not be 30,000 when my income is not that much.
What is your income?
My lord, my income in the year 2023 was 7 lakhs. In the year 2023-2024, it was 5 lakhs. And in the last 2 years, my income is nothing because I'm out of job. And my lord, they have taken the order from the lower court stating that I earn 5 lakhs monthly. My lord will kindly come to the impugned order. It has been recorded. My lord, para 4 of the impugned order. It is furthermore the contention of the petitioner that the petitioner states that the opposite party husband is in service of a shipping company as a chief officer and he is getting a huge salary amounting to rupees 5 lakh approximately per month as a remuneration.
Yes.
So this is what they have stated. They have failed to justify anything. They have just stated that I earn 5 lakhs on the basis of that they have taken this order. Now, my lord, will come to the very next paragraph of
The
the
principle is beg, borrow, steal. If you have no income, you have to beg, borrow, steal to maintain your child. That you have to do.
My lord, I am ready to maintain my child.
Yes.
Just that the maintenance amount be such, it might be reduced. 30,000 is a bit too much for me. I am ready to maintain my child.
What is the reasonable amount according to you?
My lord,
What is the age of the child?
My lord, 4 years right now.
Yes. What is the reasonable amount according to you?
My lord, I am in a position from the instructions I have got 15,000, my lord.
15,000
per month, my lord.
Yes,
For
what
the
is
husband, my lord. My petitioner, what would be my lord, the wife. My lord, this petitioner is a merchant navy. My lord, admittedly, if I could take your lordship to page, my lord, 72 was, it is our
72.
as a lordship.
Yes. Yes.
Just a minute. Lordship 72, it is the payroll of the petitioner husband, my lord. My lord, where, my lord, he used to get a contractual job, my lord, in shipping company, various shipping company. And my lord, every 6 months he is out of station for holding job. What they have done, my lord, in this petition, my lord, but how they have shown is zero income tax. Because, my lord, he is a holder of NRE account. Where, my lord, a non-resident external account, which is exempted from the income tax. All foreign amount which he is receiving, my lord, is exempted from income tax, for which he is not being able to, my lord, show, he is not showing anything in IT return, my lord. Moreover, my lord, Malik kindly takes, my lord, that he is evident to asset. No statement, bank statement has ever been, my lord, adduced in the evident to asset liabilities of the petitioner, except, my lord, this IT return file, my lord, which is, my lord, subsequently been filed.
Where is the affidavit of assets and liabilities? Where is that?
My lord, of the husband.
Of the husband.
My lord, may I take your lordship to page 136? My lord, may I just take your lordship to page 142 once?
142.
142.
Yes.
My lord, 142, column 6, my lord.
Yes.
This is the, my lord, home loan he is bearing along with, my lord, other loans. My lord, and my lord, immediately at the next page, 143. My lord, which is 33,000 per month if he is not having any income. Along with, my lord, one loan such and such, a car loan and, my lord, LIC loan, be that as it may, my lord. If he is not having
loan is 33,000
per month, my lord. If he is not
car
being able
loan
to,
is 9,000 and LIC loan is 40,000.
but if he is not being able to earn a single penny, how could he, my lord, maintain, my lord, this loan accounts, my lord?
My lord, my savings that
Your
I have
savings.
earned throughout the years, and my lord, this home loan account.
I will come back to you. Yes.
Lordship, my lord, this gentleman have never paid a single penny, my lord, from the very birth of the child, my child. Never paid. What he urges, my lord, he has proposed to give 2.5 lakhs at the time of birth, which he did not have given. Never give, my lord. And from that, my lord, immediately after the birth was, my lord, on February 2022. On June, my lord, 23, we filed a divorce suit, my lord. And every divorce suit, every now and then they are playing with the court below, praying for an adjournment, seeking that yes, he is out of town, my lord, out of station due to his contractual engagement. And now he is coming in before this honorable court and saying that no, I have no income.
Where is your application under section 36?
My lord.
My lord, page 54.
Page 54, my lord.
Where is the details of this expenses on account of alimony? Where have you stated?
In my application, my lord.
Yes.
But in evident asset liabilities, I have stated.
In the application?
Yes, my lord. May I just point it?
4-year-old child.
4-year-old child. He is now
40,000. It's necessary. For what?
My lord, 40,000, 30,000, granted 30,000, my lord.
But you have claimed 40,000.
My lord, as per the standard of living of the husband, my lord. He's used to get, my lord, equal standard.
Have you given any breakup of this 40,000?
My lord, may I just
lord,
take a look
page
at every asset
125.
liabilities, my lord.
Yes, page.
125, man.
Please, I will come back to you. Yes, page.
Page 124 onwards, my lord. 125. 125, my lord. This is my asset and liabilities, my lord. 126, my lord, perhaps.
So what is page 130? Clause H, details and liabilities of the deponent. You have taken a home loan.
It is joint home loan, my lord. Of the husband and the wife. At that point of time, the husband has taken, my lord.
My lord, the very home loan he mentioned.
So who is paying this
Husband, my
EMI?
lord. Husband is
Me
paying.
is paying. I am paying.
Husband is paying, my lord.
Husband is
is
paying.
paying. I am from very beginning, I have been residing in my parents' home, my lord.
Vehicle loan and the house building loan. Both
Vehicle-
are the husband is paying.
Vehicle, my lord, he used to use his own vehicle, my lord. And my lord, there are several receipts, my lord, which my lord, my learned friend is annexed, my lord, of the page from 80 onwards, my lord.
80.
80, 81 onwards, my lord.
Yes.
And schools, my lord, Medicaid, the different, my lord, money receipts, my lord.
Yes.
My lord, because my lord, as 10,000 I have to pay to the, my lord, daycare, my lord, baby care, to my lord, maid, my lord, who is taking care of my baby. And there are several, my lord, and used to, my lord, go to swimming class, coaching classes, several attending, my lord.
Yes.
And my lord, this, as petitioner is, my lord, the petitioner is receiving in dollars, my lord. And for which, my lord, the NRE accounts holder is exempted from tax. He is showing that yes, there is no income tax return, my lord. Zero.
Yes.
And
My lord will kindly come to page 127 once.
127.
127.
Yes.
My lord will see column C, third, the approximate expenses incurred on account of the dependent rupees 40,000. This is what she has stated earlier, 2 years back, when the age of the child was 2.5 years. And these are only food expenses, only that. Now, my lord will come back to page 125, which has been filed just before the order was passed. 125 is the expenses incurred on the child. So, on one hand, she is claiming 2 years back the cost was 40,000. But when she has to justify the cost, her own cost is coming down to 34,191, which is also inflated. My lord will kindly see the school transportation fee. 5,000 for a child which goes to a school in my own locality. 5,000 is the cost that they have increased. My lord, 10,000 rupees towards fooding. She's a 4-year-old child. These are just costs which have been increased. And even then, her own 34,191, it is not even 40,000. Her own demand was 40,000. But when it came to justifying it, she has not been able to justify. And that is 2 years after the initial claim of 40,000. And as far as the home loan was concerned, she has stated in her own affidavit that she is paying for the home loan, or she has taken a home loan, but the entire money, the entire EMIs are being paid by me. It is in the joint ownership, but I am paying. Everything is being paid by me. She is a working woman. Plus, she has stated in her affidavit that she is employed in CK Birla, where 29,000 is her salary, but currently she is not. She is with Peerless and she is enjoying a salary of more than 45,000. Her own advocate stated that in the lower court. They have not filed their updated affidavit of assets. Right now, she is not with CK Birla. She is with Peerless.
Since when?
Since, my lord will give me a moment. My lord, since the month of April 2025. I have stated it in my para 8, page number 4.
Yes, where
Yes,
will be,
my lord. He is now in my lord Peerless Hospital, and
what
it
is the current income of the wife?
45,000. He's admitted, my lord, and he has also filed the relevant documents, salary slips with the learned court below.
No, my lord.
Yes, my lord.
None
He has
of the
said it, and it is in on record, my lord. Because after that, he have given all this copy has been handed over to the learned advocate of the husband also. That he is 45,000 his income. Yes, it is admitted, my lord. It is not disclosed that he is not earning.
The trial judge considered that.
No, my lord. Trial,
Show me.
no, trial judgment had not considered, my lord, as it was not an evident asset and liabilities. Because asset and liabilities was filed, my lord, previously on 2 years back when he was having, my lord, the salary of 29,000.
But then you have also to bear the share the expenses of the
I am
child
taking,
also.
my lord. I am taking the bargain because till date, my lord.
According to your own estimate, the expenses is 34,000.
My lord, 34,000. My lord, in
That's
this
your-
present scenario, my lord, present extreme high rise.
That's your statement given when?
Lordship.
That's the statement calculation given on which date?
But it is given prior to the date of my lord hearing, my lord. On the date of prior to date of my lord.
itself.
Yes, 2026.
My lord, it include, my lord, total expenditure. My lord, there are several also other expenditures.
What are the other expenses, sir?
My lord, can you see, my lord, caretaker 9,000, my lord, swimming class.
Caretaker.
My lord,
What
for
caretaker?
looking care of the baby, my lord. Because, my lord, he is also working.
All expenses you have included here.
Yes, my lord, all
Even
expenses
then
included.
it's 34,000.
Yes, my
You
lord.
have to share a part of that.
I am ready to share, my lord. I have been taking care of my child, my lord, from the birth, my lord. He has not paid a single penny, my lord. Let them show, my lord, yes, he has paid a single penny.
Your income is 45,000. You have to share something from the child.
Yes, ma'am. I am taking, my lord. I am sharing, my lord. I am taking the burden to burden on, my lord. I am
From 34,000, you have to share something.
My lord, if it is
That's your
34,000,
That's
yes,
your
my
calculation. He
my lord,
says
lordship kindly,
inflated.
beard, my lord, lordship kindly appreciate one thing, my lord. My lord, the status he is belonging, my lord. He should also, given the status of the child, my lord, he should also enjoy the same status, my lord. Child also enjoy the same status because he is, my lord, studying in now in a nearby school, my lord, not nearby. Is a convent school in Chuchura, where, my lord, this petitioner wife is residing, my lord. If he is being taken to, my lord, other school, he need to be just more, my lord. More expenditure is, my lord, the husband is not giving a single penny till date. And now, my lord, the wife from the very inception, after the birth, my lord, he has filed dissolution of marriage. My lord, kindly takes his pleadings, my lord.
Or what is the stage of the suit?
My lord, it is practical evidence. I have to take instruction, my lord, because it just state as well as the PW1 is not available. Husband wife is not available because he was out of station by several days. But it was filed on
Now it's
2023.
the evidence of the husband.
Yes.
When you can lead your evidence? How soon can you lead your evidence?
My lord, on the date fixed before the trial court. On the next date fixed.
But every date, my lord, if your lordship could desire, my lord, I could produce those documents, my lord, all record.
And my lord will also come to page 155 for the order, last page of the order, my lord.
Yes.
My lord, page 155. This quote, I'm just reading out what the learned judge below has considered while passing the order.
Yes.
This quote is of the considered opinion that admittedly the OP husband is an MSc in nautical science and is working in a shipping company. Even though it is admitted that the petitioner wife is also an earning mother, does not absolve the OP husband of his responsibility of maintaining his minor child as per his own standard. So, my lord, the learned judge has considered I am earning 5 lakhs a month, which is untrue. Then he has equated my educational qualification to my monetary status, to my financial status. There are so many people who are earning lakhs and crores of money who are not so educated. Education and financial status cannot be compared. Both are not similar.
Anything more?
My lord, I'm just praying that the maintenance be shared. And my lord, one more point. The order has been passed that I have to pay the maintenance from the date of filing of the application.
Yes, my lord.
That's
My
the
lord,
law.
at least since the
the
date
law.
of the order.
My lord, from
That's the law.
My lord, if at least it be shared, the maintenance be reduced.
my lord, on 2020, my lord, he used to earn 5 lakh per month, my lord.
This application under Article Mother, you have to
Lordship,
share.
I'm taking them. I'm taking. I definitely take them. Grateful, Lordship.
21, my lord, I am for the petitioner.
Yes.
My lord, my application where I have challenged, my lord, two orders. One is, my lord, an order passed under section 36 of the Special Marriage Act, directing the petitioner husband to pay maintenance of rupees 6,000 to the opposite party wife. My lord, on the date of passing of that order, before passing of that order, I have filed an application seeking, my lord, praying for, my lord, allowing me to adduce evidence as a DW. That application was kept pending. That was subsequently, my lord, disposed or dismissed, since it became infructuous for the, my lord, the purpose of, my lord, since the miss case has already been disposed of. That application, that order, I have also challenged in this application. That was, my lord, rejected on May 2026. So I have challenged both the orders, my lord. The order impugned, my lord. First order is, my lord, order number 71 dated 9th of September 2024, where, my lord, section 36 application was disposed of by the learned court. And on the same day, prior to passing of this order, my lord, I have filed this application. The application I have annexed at page 69, annexure G. That application was subsequently, my lord, rejected on order number 81, 9th of April 2026.
Yes. What evidence you want to lead?
Well,
you have filed your affidavit of assets and liabilities. What more is required?
Wife has suppressed, my lord. She is getting, my lord, the maintenance from domestic violence proceeding. That has not been disclosed in her affidavit of assets.
That can be.
So far, my income is concerned, I have stated my income in my affidavit of assets.
Yes.
But the proof I could not produce, my lord. That evidence I would like to produce before the learned court. That
What is your income?
My lord, my income is 15,000.
Your income is
15,000.
15.
Yes, my lord.
Yes.
And the wife is staying at the same residence. There is no, my lord, child.
Yes, the court took into consideration your income of 15,000.
Yes, ma'am.
Yes.
And there is no, my lord, disclosure of expenditure by the wife. She is staying at my home.
Yes.
She is staying at my home. There is no explanation as to why, my lord, she has, my lord, paid for 10,000 rupees. But in her affidavit of assets and liabilities, she disclosed, my lord.
But it has been granted only 6,000.
6,000.
6,000, it's nominal.
Your lordship would kindly appreciate, my lord. I have my own mother, my lord, age-telling mother,
Maybe.
above 70 years of age.
6,000, below 6,000, a person can be maintained.
She is staying at my own residence.
Yes, there are no other expenses. Also, bear her fooding and other expenses.
There are, but your lordship would kindly appreciate my responsibility.
200 rupees per day.
My responsibility.
200 rupees per day, 3 meals can be arranged. Less than 200. What are you saying?
Lordship would kindly appreciate, my lord. Only one opportunity may be given so that I can adduce my.
I'm accepting your evidence. 15,000 accepted. I'm accepting your case. Even then, I'm asking you.
I have my own expense, my lord. Let me.
Maybe whatever expenses you have, you may have. But you have to, below 200 rupees per day, no one can be maintained.
The lordship would kindly. I am earning 15,000 per month, my lord. I have my responsibility towards my mother as well, my lord. Widow
Yes,
mother.
yes. You have also to look after your wife as well.
Yes, my lord. That is true. That
Yes,
I am not. She is residing at my residence. The lordship kindly.
Maybe residing at your residence does not mean that you are bearing all our expenses.
No, definitely not. That is why she have come up for this application. But the thing is, my lord, I have my own expenses. I have to also look after my expense, my mother's
do that. And you are challenging an order of 2024 in 2026.
Well, I have filed an application. That application was kept
That's
pending.
neither not a ground for coming after 2 years. Yes, what is the other order which you are challenging?
Well, my rejection of application for allowing me to adduce evidence. Order number 81, my lord.
81.
Yes, my lord. 9th of April 2026. Since the miscase.
What remains in that application?
Yes, my lord.
So after that order has been passed, what remains in the application? This application has become infructuous. You ought to have challenged that order at an earlier date.
But my application was kept pending for 2 years, my lord.
This application under Article 227 of Also,
I have taken this point.
the particular. Uh,
Need to.
yes.
There are two suits. Now, my lord, in one suit, my lord, I am the plaintiff, and in the other
Stay, section 10.
not section 10. My lord, what happened, my lord? Two suits, my lord, one suit, declaration of title, both the suits. One suit, I am plaintiff, my lord, other suit, the defendants are the plaintiffs. Now, my lord, what happened, my lord? My suit got dismissed, their suit got allowed. Now, my lord, I prefer two appeals. My lord, one of the appeal, my lord, title appeal number 46, which was filed, my lord, against dismissal of my suit and my claim. My lord, in that, my lord, I filed an application, my lord, under Order 39 Rule 1 in nature of injunction. My lord, thereby directing the appeal court to, my lord, pass an ad interim order protecting my possession, which is admitted by the parties in the trial court, and trial court found on that I am in possession. Now, my lord, that ad interim order stood refused. My lord, kindly sees, my lord, the impugned order, which is.
Please show me the order of injunction.
Yes.
Any order of injunction passed in their suit.
Yes, in the suit.
In their suit.
Both the suits were, my lord, heard together in that.
Yes, in what in their suit, what is the order? Please show me.
My lord, kindly takes up, my lord, page 17.
Yes.
That is the order, my lord, kindly sees the top portion, two suits were taken up together. Now, my lord, kindly takes up the relevant portion without troubling my lord with the entire.
You are the plaintiff in which
title suit number 186.
186.
Yes, I am the plaintiff.
So you have been restrained, permanently restrained
No.
from forcefully entry into the suit land.
No. My lord,
that's the decree. What are you saying? No.
My lord,
It's going to come to 79.
My lord, decree. To decree.
Yes.
My
So
lord,
if you are suffering an order of permanent injunction restraining you from entering into the land, and by way of an interim order, that injunction is to be passed.
Kindly takes up the decree, my lord. Kindly takes up the decree, my lord.
Maybe. I cannot modify the decree now without hearing
It's not about
that.
decree, my lord. Kindly takes up, my lord, the order which I am
Ad
showing.
interim refusal, contested.
Trial court found, my lord, that I am in possession. The decree doesn't find.
Mr. Chatterjee, this order stands unless it is set aside.
Yes.
So it cannot be set aside at the ad interim stage. The effect of the order which you are now seeking is to negate this permanent injunction decree, thereby granting injunction in your favor without hearing the other side. Cannot be done. That means virtually their suit is dismissed, your suit gets decreed without hearing them. How can it be done at the ad interim stage, Mr. Chatterjee?
Now, my lord, kindly takes up page 17. Kindly takes up.
Mr. Chatterjee, I cannot go into that.
No, my lord, kindly takes up page 17, my lord. What I am trying to show, my lord, that will be gathered from here. My lord, the trial court, my lord, on remand by High Court, categorically found I am in possession. My lord, this decretal portion.
Then the decree has been passed restraining you from
My lord,
forcefully.
in the decree, my lord, I could not find a single finding to the extent that the defendants were in possession.
Mr.
Now, my lord,
Chatterjee, what you
happened-
are saying, get the injunction order upon a contested hearing.
Now, my lord,
So you will not be affected if you are in possession. You remain in possession.
Kindly seize the order.
What is the next date fixed?
Have
Have you
23rd September.
23rd September and directing the injunction
Kindly
application.
takes up the Honorable High Court's order in this.
Mr. Chatterjee, I cannot go into
Milord, there is
that.
an order of status quo. Milord, what happens? Milord, tell your lordship, Milord. The reason, Milord, which has been cited by the learned trial court in the ad interim stage is, Milord, since the suit has been dismissed, Milord, he cannot pass an order. Milord, that is the reason. Milord, if that is
Not
the
only
reason.
suit dismissed, Mr. Chatterjee, here there are two suits. Please consider this. Even if a plaintiff files a suit gets dismissed, yes, considering injunction can be passed. But there are two suits. So in one suit where you are the defendant, you are suffering an order of permanent injunction, restraining you from permanently entering. And here I will be
am
granting
showing
you
that I am in possession. Milord, that's exactly my point is. Before the appeal court.
So why are you afraid? Let them come.
No, Milord, the court has found. Kindly turns to page 26.
Interim order? No. This will amounting to modifying that.
Milord, I understand. Milord,
Cannot be
kindly
done.
turns to page 26 once. Kindly turns. I understand what is falling from my lord. My lord has got page 26.
Yes.
Milord, in the middle portion, hence it prima facie.
This was at what stage?
Milord, at the injunction stage, Milord, this was on remand.
That was the prima facie finding at the injunction stage. But in the final hearing, the decree is operating against you.
Exactly.
There's a difference between prima
Exactly.
facie finding and a final finding.
Exactly. Now, my lord, if I could have understood what is falling from my lord, if the decree, my lord, judgment decree, spelt a single line showing that I have found, my lord, the defendants are in possession.
Very good case. You can succeed in the appeal, in the title appeal.
So therefore, my lord,
one
today,
day your appeal will be allowed.
If today, my lord, kindly
Decree will be
appreciate.
set aside, Mr. Chatterjee.
Today, my lord, if I am in possession, my lord, and by this order, my lord, they re-enters into the possession. My lord, what happens? So, my lord, at least a status quo order, my lord, may I just rely upon a decision, my lord, of the court, the Honorable Supreme Court. Lord, kindly 6, my lord, 2025 SCC online SC 2526. My lord, kindly takes up paragraph 2. My lord, the order which was passed is exactly what order has been passed here. My lord, we find the impugn order prima facie but bit unusual. The appellate court says that since the suit has been dismissed, no interim order relief can be granted in appeal. Now, my lord,
Mr. Chatterjee,
now the
there is
honorable
no dispute with regard to that. Here, there was only one suit. Suit get dismissed, and the question is whether at the appellate stage injunction can be granted. There's no quarrel to the proposition.
No, my lord,
but in the case where you are
here,
suffering an order of permanent injunction,
to obviate, mitigate all problems, my lord, what Honorable Supreme Court did is, my lord, at the interim stage passed a status quo. Now, my lord, if status quo is passed, the Supreme Court is of the view that if status quo is passed, then all problems will be start keeping that status quo in force directed in 2 months, what my lord is saying. Now, my lord, if I can show today, my lord, prima facie, the trial court at one stage finds me in possession at the interim stage, which may not have a final bearing. But in the impugned judgment and decree which is there on record, if there is not a single line on that I have failed to show my possession or the defendant has failed to show.
Chatterjee, passing an interim injunction in your favor, what will be the effect?
My lord, if my lord today wants, my lord, then a status quo, whoever is possession will be there. My lord, nobody is touching.
Then I will indicate the decree also.
Yes,
status quo,
because
this is the decree,
because what
that is the status quo which is to be maintained.
Now, my lord,
Strategy cannot be a
now, my
vague
lord,
order.
kindly sees what the appeal court does is, my lord, on the first paragraph.
You are opposing, you are showing status quo, status has to be indicated.
Exactly.
Status quo order,
The
vague should not
the
be
judgment
passed.
decree doesn't show that status. Judgment decree mechanically, my lord, passes the
Not
decree sought for.
Mr. Chatterjee, mechanically, not mechanically, please you succeed in the
Then, my lord, today, my lord, kindly appreciate. Today, my lord, if today, my lord, if I can prima facie show before today, now, here and now, or in the appeal court, that I have a case. Now, my lord, in the meantime, till such time, my lord, if I am dispossessed or the property is disposed of in such manner, my lord, what happens?
You are not in possession. You have been forced. You have been restrained. That's the decree.
That's a decree, my lord.
Mr. Chatterjee, that cannot be modified in at the interim stage.
What the appeal court has said, or appeal kindly sees the last penultimate paragraph.
I can supply the reasons.
No, my lord, kindly takes up once, my lord, for my satisfaction. I know, my lord, what I'm troubling, my lord. The last paragraph is moreover, after going through the materials available on record, at this stage, this court feels that it is not proper to pass an order of injunction against the operation stay. But I have never prayed for stay of operation of the judgment and decree. Because
Mr.
this I have
Chatterjee,
not prayed.
Mr. Chatterjee, there is a decree of permanent injunction operating against you.
Yes.
And an injunction passed in your favor. What's the effect? What will be the effect?
Well, then maintain a status quo saying that whoever is in possession, let that status be maintained.
Anything more? This application under Article 227.
if 23rd is the returnable date, my lord, kindly have a liberty, give me liberty to prepone it, my lord, if I can show the service is ready.
Have you served?
My lord,
You
served.
have not yet served.
I've served, my lord. There I have already sent for
Uh,
service. If I can
the-
show pre-service, my lord, liberty to.
The learned judge of the appellate court is requested to take up the hearing
May it please your lordship, Lord, I'm appearing for the petition and the matter. Briefly, may I indicate what the matter is?
Yes.
Dear my lord, the matter has a checkered history. I'll be very brief. There's a property. It is an undivided property, joint property, undivided. This
What is the
property
order under
mortgage.
challenge? What is the order under?
Order of DRT, which is under challenge. Not under
Yeah.
challenge. I'll indicate why we have filed a 227. What has transpired here? Joint property, undemarcated, undivided, mortgage behind our back, without any partition. Now, this mortgage is absolutely bad in law. So this mortgage does not satisfy the test of legal necessity, the benefit of the estate, and to discharge an antecedent debt. The HUF principle that is not there here. It was for a loan to be taken from the bank for other business purposes. Now they have defaulted.
Your co-sharer, your co-sharer.
Co-sharer. They have
Yes,
defaulted.
your co-sharer has taken a loan.
They have taken a loan without our
They have
permission.
mortgaged this
They have
joint
mortgaged
property.
the entire property. When we came to know this, we immediately made inspection as to how this has been done. We find that in the KMC records, they have changed the mutation. In the records, we never had a notice. We immediately filed a writ petition before the Honorable Court. The Honorable Court took cognizance. That order is on record. I'll show that order. The Honorable Court held that you could not have done this without giving a notice to the co-sharers. This is absolutely illegal. Struck it down, reverted the matter back to the KMC authorities.
What is the impugned order here?
The impugned order, I'll just come in 2 minutes, I'll indicate. The KMC then reverted back, they cancelled the mutation, reverted back to the original position, which is now standing. It's in the name of the predecessor still now. In the meantime, since they have defaulted, the bank proceeds before the DRT in the Sarfazi action. And we filed a suit before the Alipur court, challenging the mortgage, saying the mortgage is absolutely illegal. It's a fraudulent action. In collusion, the bank officials in collusions with the other co-partners, co-sharers. We get an interim order. We get an ad interim order in our favor. Ad interim order continues for almost 2 years. There was a stay in the entire proceeding. One day, we appeared in the first half. Second half, the matter was taken up. When it was indicated, the matter will not be taken up in the second half. No change in the facts and circumstances of the matter, but because no one represented and a petition was not filed for extension,
Ad interim order was vacated.
It was vacated. We filed a revision therefrom. That revision is pending adjudication before this Honorable Court for reinstating the interim order. In the meantime, the bank proceeds. There is a sale. We file 2 petitions. One is a essay petition, the Sarfazi application, which is pending, the main matter where we have challenged the entire proceeding. In connection therewith, we filed a stay because we came to know there's an auction which is going to now happen. We filed a petition for stay, which is to be considered on merits. In the meantime, we come to learn that the auction, we mentioned the matter was not being taken up. In the meantime, we come to learn on 10th of July, 2026, the auction has been proceeded with, the property has been sold. On that day, we come to know it has been sold to X party. We take out an application for impleadment of that party before the DRT proceedings. Along with that, we also pray for the stay. Because if there's no stay of the main proceeding. So not only the stay of the sale notice, the auction, but also any further steps taken by the bank. Otherwise, we will be standing remedialist. At this juncture, the DRT hears out the matter, but hears out only the impleadment, does not permit us to make any submissions because it was hard pressed with time. The Honorable Bench said, all that we are doing is we are allowing your application. We said there's also a stay petition that is to be heard. Nothing heard. The petition was allowed. The stay petition is still pending. My only prayer today is kindly direct the DRT to hear out the stay petition. Otherwise, today the sale is concluded.
There is no sale certificate issued. In terms of the recent Supreme Court judgment in Cellier LLP, once they issue the sale certificate, my right of redemption goes completely. And I will stand remedialess. My prayer today before this honorable court is a direction on the DRT. That is why 227, a direction on the DRT that they hear this expeditiously, the stay petition on merits. And in the interregnum, I'll pray for a stay, because today if the sale certificate is issued, then I'll stand remedialess in the matter. And there's a clear-cut fraud. That is why we had an order of ad interim injunction in the suit. May I indicate? We have proceeded under section 17.
Please give me a minute.
My lord.
Yes.
Lord, section 18 of the SARFAESI Act would not apply in the present facts. My lord, I'll indicate why. But there is no order that we are aggrieved by. We are aggrieved by the inaction. Because, my lord, today, if your lordship kindly, perhaps that is what was troubling your lordship, whether this is an appealable provision. My lord, we are aggrieved by the inaction of not considering the stay petition which is pending adjudication. Your lordship will kindly take up the orders which are annexed from page 393 of volume 3. Will you kindly take up page 397?
397.
397, volume 3, my lord. This is the order, my lord. (397), volume 3, my lord.
Yes.
This is dated, my lord, 29th of July 26.
Yes.
Lordship will find this is IA 1917 has been placed along with 1919 being put up. Since record is put up, 1919-26 is disposed of. 1917 has been filed for addition of auction purchaser. Prayer is allowed. Essay is directed to appear before the registrar on 18th August. 1917 is thus disposed of accordingly. So that is, my lord, the application for impleading the auction. Lord, kindly see the previous page, my lord.
Yes.
Your lordship will find IA 1791 has been placed with put-up petition 1793. 1793 is the put-up petition, my lord.
Yes.
Since case record is of 1793 is disposed of, it's placed, hence it is disposed of. 1791 has been filed for setting aside sale notice, contemplating sale. So that is, my lord, the stay petition. This is not being heard of. My lord, this is not been heard out. At the outset, counsel for the respondent bank submits sale was successful. Respondent bank is directed to disclose the name. So, my lord, that is the disclosure by which, my lord, we file the subsequent petition for addition.
So you want this
We want
1791 to be
17. I'm very grateful, my lord.
What is the next date fixed for of that?
My lord, the next date is, my lord, there is no date fixed for this, my lord. That's the
So
difficulty.
what is
My
the
lord, you will
next
kindly
date fixed in the essay?
The essay, my lord, is 23rd. It was on 23rd of July 2026. No date given yet. Any date given specifically? The date, kindly grant me a moment. I'll indicate, my lord, the next date. Tatari bolo. But 1791 not being heard along with the, my lord, main essay. Your lordship will find page 395 once.
Mr. Baglan, advocate appearing for the petitioner submit. pending. Yes, next.
But if it is issued, my lord, our proceedings will become infructuous, my lord. That is the reason, my lord.
For that, then, if you say that your interim protection was not granted, then it's appellable. Your interim relief is
It is not considered only. That's the difficulty, my lord. It's not
considered means yes.
Understand,
Ad
I
interim
understand.
prayer refusal,
Understand.
it's an appellable order.
Understand.
You have to move before the DRAT.
It is not taken up. So I understand, my lord. I'm very deeply obliged. Deeply
Yes.
obliged.
Yes.
It's an application for expeditious disposal
Of what?
of title suit on
What is the stage of the suit?
My lord, the stage of the suit was fixed for cross-examination of PW1. However, after
So
25,
why it has been fixed for taking necessary steps by the plaintiff?
my lord, that is the I would crave leave to refer to the last order. An application was filed because plaintiff number 3 died. That was allowed. Now it is fixed on 6/10 for filing for hearing of petition of order 6 rule 17.
This application under Article
My the judgment of reversal by the lower appellate court allowing
injunction.
Yes, allowing the injunction.
Allowing the injunction.
Disposal of the suit. By this order, my lord, somebody has been put into possession. I have been ousted from the possession. Title has practically been decided against me. And my lord, completely contrary to the case. And my lord, very importantly, putting words in my mouth, completely misinterpreting my written statement case. My lord, kindly seize the order impugned once, my lord.
No, in the suit, who are you?
I am the defendant in this suit.
So in
I
the
have a prior suit as the plaintiff claiming adverse possession. That's the prior
suit. The application under Order 13 Rule 1 and 2 was dismissed.
Was dismissed.
Miscellaneous appeal and injunction has been passed.
Till disposal of the suit. So it's a judgment
It's a
of
contested order.
It's a contested order. Now the problem is, my lord, I'll show from the written statement that what I have not stated has been said that I have stated, I have admitted. I have marked specific portions. I'll take your lordship to that. A. B is what I was in the possession, plaintiff was not. Now today, basically I have been ousted and plaintiff has been planted in. Plaintiff was not even in possession. And I, my lord, cultivate tea, so my right to business is also lost.
But Mr. Gupta, stay cannot be granted on this.
My lord, I was discussing the exact thing which is falling from your lordship with my juniors, but the only difficulty.
Stay cannot be granted. I can direct you to serve without.
I'll have to do that, but only one thing. kindly directs, kindly passes an order not to, my lord, oust me.
Mr. Gupta, there is a different roundabout way. It's amounting to stay. How can that be
How
done?
how can I be ousted, my lord? Your lordship would kindly consider, my lord.
Without hearing them, it cannot be passed. It's a contested order, good, bad,
I
indifferent.
completely bow down, my lord. Your lordship would
So
kindly
if
find
your
out.
prayer is allowed, it amounts to.
I'm also allowing the revision. Absolutely, my lord. I fully bow down.
Know this.
But only one thing
Even then you are saying.
No.
Ashok,
Only one thing. Only one thing. Your lordship would kindly, my lord, use some of your lordship's expertise, my lord, to protect me something. Otherwise I have been ousted, my lord. He has been planted in. He has put my lord new flags here and got the police to oust me. This is what is happening with this order. And he is throwing pesticides on my tea bushes. But I completely understand what is falling from it. That is the position. But kindly give me some glimpse of my lord, some protection.
How can that be granted?
But some sort of, my lord. I leave it to your lordship. I'll not say a word more. I leave it to your lordship. Your lordship would be shocked to see how my written statement has been interpreted, that I have admitted joint possession.
What is the suit
Ownership.
for? What is the suit for?
Suit is for, my lord, really declaration. Suit is filed for declaration injunction. I have a prior suit of adverse possession. Now, my lord, that has not been really looked into, one-liner, brushing that aside. My written statement, I have said that how
Adverse possession against whom?
against the plaintiff, and here what the plaintiff has done to couch it.
What happened to that suit for
That
adverse
is pending. In fact, today date is fixed for filing of written statement by the plaintiff here.
Therein you have obtained any injunction order?
No. Now, in this suit, what the plaintiff does, what the learned court below does, the lower appellate court, the lower appellate court says, in my written statement, I have admitted co-possession, co-ownership, which is not the case. Well, your lordship would kindly have a look at my written statement once. I have said that plaintiff has no right. But what happened was, there was a understanding between my predecessors and the plaintiff predecessors. So, my lord, one plot of land I have gone into, one plot of land the plaintiff has come into. Because the record of rights shows both the plaintiff's predecessor's name and my predecessor's name.
You have filed a counterclaim.
I filed a counterclaim.
In counterclaim, you have claimed that you are a co-sharer.
No, my lord. That's the impugned order.
Yes.
Kindly
Please show me your counterclaim.
Yes, exactly. I wanted to take your lordship to that. Kindly see page 110.
110.
Yes, my lord. Kindly see the written statement once, my lord, page 120.
So please show me the counterclaim. Where is the counterclaim?
Prayers at page 117. I'll also show from the written statement. Paragraph 17, page 116, clearly pleaded they have no right.
But the record of rights says jointly owned by 3 groups of recorded.
3 groups, yes. So it's the order impugned proceeds on the basis of the plaintiff have the exclusive right name in the record of rights. I'll show that, my lord. And kindly seize my written statement once.
Sir,
but some kind of protection.
Mr.
Would your lordship kindly direct the status quo to be maintained, not to throw me out at least?
Status quo would be amounting to modifying that. An order of injunction modifying to status quo.
Kindly makes the returnable date in the shortest possible time, my lord. Otherwise, my lord.
By the order Oh, it's difficult. Yes, yes.
My lord,
next.
otherwise, my lord, if your lordship does not grant any protection, my lord, I am being ousted, my lord, from the property.
You have been
I
already
have been-
posted. Yes, yes.
No, I have
You are in
not-
possession, you remain in.
But kindly gives a status quo order, my lord, as on date, my lord. That your lordship can pass. My lord, that much if your lordship
Then I
can
have to record reasons, Mr. Gupta.
My lord,
What is the scope of an
But
miscellaneous?
I can readily satisfy your lordship. My lord, otherwise, this would be
Yes, yes,
infructuous.
yes. Next, call the next matter.
My lord, kindly, my lord. Otherwise, my lord, I will be thrown out, my lord.
Motion I have said, otherwise contested application. This will be a contested matter. That you have got motion. Yes, yes, call the next matter.
Lordship, the learned counsel in this matter for the petitioner lordship is engaged in court number 446. Lordship, I'm praying for a very short passover, lordship.
Yes, what is the order impugned?
Lordship, I'm not instructed, lordship. I'm praying for a very lordship short.
Who is
passover.
appearing?
My senior is appearing in this.
What is the name of your senior?
Mr. Dhananjay Banerjee. Mr. Dhananjay Banerjee, lordship.
Yes. What is your name?
My name is Mahiul Islam.
Where is Mr. Bishwajit Sarkar?
Lordship, that I don't have knowledge.
Ask him to come, pass over. Yes.
My lord has fixed a matter on that 3, my lord. No, my lord has fixed a matter at 3, my lord.
Yes, please wait. Yes. Yes.
I am for the petitioner.
For the caveator,
Petitioner filed a title suit, my lord. In the title suit, the order passed and title.
Yes, Mr. Ghosh. Do I have any difficulty in taking up this matter? Yes, yes.
Status quo order passed, my lord, 8/9/2020.
Status quo order, yes.
Yes. For status quo order, my lord, petitioner filed a misappeal. In the
filed a?
Filed a misappeal, my lord.
Yes.
That misappeal was a status quo, set aside the status quo order. My lord, can you see the order?
What is the suit for?
Suit for declaration and injunction.
Please give me a minute.
Petition undemarcated property. One of the shareholder, he get 1 decimal land. He has made a agreement, my lord, with the 2015. He was not a shareholder. Vishwajit is a developer. He has made agreement, my lord. On the basis of agreement, she construction the building on 10 decimal. Made on the agreement. Not only that, it is the undemarcated property.
Why did not disclose the death of Ponomali?
Ponomali, my lord, page.
Why did not disclose the death of Ponomali? Why his heirs were not substituted?
His heirs is disclosed, my lord. Yes, Ponomali 8 son.
Why did not disclose the death of Ponomali? It's an equity injunction. The court has found you have suppressed this and have obtained an order of injunction, right?
Injunction status quo order, my lord.
Maybe status quo order. Why the status quo order will remain? without indicating the status.
Undemarcated property, my lord. There are petitioner, he get 4 decimal. How he construction 10 decimal land? Not only that, land has not demarcated. Only before the order 10 decimal manner, Shamoli are, they already sold the property 3 decimal. 1 decimal.
Yes,
cash.
Mr. Ghosh, what do you say?
The kindly comes to the plane. Plane, page 16.
Yes.
One of the petitioner before my lord is the plaintiff. One of the I am the defendant number 1. Now the form serial number 2.
What is the suit for?
The suit for declaration and permanent injunction. Now the other co-sharers have made the pro forma. My instruction, the serial number 2 pro forma defendant number 2 expired.
Ajit Kumar Das?
Yes, the 7 day diet, 8 expired, 9 expired, 10 expired, 11 expired, 13 expired. All the against the dead person, and Bonomali is also there.
So they have been included in the suit, in the civil division application also. Dead persons.
Civil division party hai.
Yes, Bonomali is also a party.
Yeah,
so Bonomali has passed away. How can we
Bonomali
include the dead persons as a party?
Now, Bonomali's daughter, transferred their share in.
Ghosh, please check up. These opposite parties have also died.
Bonomali 6, kindly comes to cause title 3. All, kindly comes to cause title 2. This is set out. All these are dead person.
I'll take instruction.
These
what
are
are you doing? This Bonomali, there is a finding, he has died, and you have implemented him.
But they are not objection at the time of my, they are not objection.
What objection?
Bonomali,
The impugned order, it has been recorded. How could you make a dead person a party in the civil division application?
Passing order, they are not raised, they have objection, my lord. Now they are objection.
So, what they have no objection? On that ground, the injunction order has been set aside.
By suppressing that,
file a civil division application against a dead person. Ashun. Yes, what do
otherwise, I'll take instruction.
What instruction? Bonomali is dead. It appears from the order itself.
Otherwise, can dispose of the matter and expeditiously hear me over the child suit.
How can that be done? Dead persons are on record.
Only appeal court that is already passed an order. Can you see?
Then if the appeal court has already passed an order, what is the direction necessary? What do you want now? Please tell me.
Now, my lord, stay the order, my lord. Stay. Stay the impugned order. Status ko already, my lord.
Stay the impugned order. বুঝো মরা লোকের নামে মামলা করেছে আবার বলে stay the impugned order. What do you want to do now? You are not appreciating what is the kind of revision application is maintainable against dead persons. After some argument, the learned advocate
in between, though there is a map, they have prepared a map, with the surveyor have prepared a map, though that has not been disclosed in this petition. But there were also that has got no signature, or it is not by any court of law, there is nothing, but there is an amicable settlement. On basis of that amicable settlement, your lordship, the petitioner's mother, they are possessing a particular portion in that suit property. Well, the father of the petitioner died. He passed away in 2013. Thereafter, my lord, this amicable settlement happened in January 2016. No, your lordship, it happened in May 2016. Thereafter, your lordship, there was, after on basis of that, your lordship, the mother and the sister of the petitioner executed deed of gift to the petitioner, which is the basis of this suit, because he inherited the right and title over the property. Now, that deed of gift, which gives him the right, is a part and parcel of the suit, partition suit. But that has not been annexed over here. It is very interesting. It has not been annexed. My lord, why not annex, your lordship? Let me show your lordship. Here, my lord, in the partition suit, this deed of gift, my lord, I have a deed of gift, my lord. May I read some portions of the deed of gift?
So deed of, no, only one thing. What is the reason why it was rejected?
My lord, I'll come. Why it is until and unless I narrate this background of your lordship, may I? Why it was rejected?
See, one reason I find that one of the ground is that the trial has begun.
No, apart from that, that
is one of the reasons.
No, there are the main reason is separate. Why I say, your lordship, the petitioner acquired the right and title through this deed of gift by his mother and daughter. My lord, in the deed of gift, your lordship, may I read? It is stated, my lord, they have not annexed. My lord, after in the deed of gift, my lord, may I read it?
Please show me the reasoning.
Yes, my reasoning is why I'm telling the background, because your lordship, they have filed an amendment petition. What is there in the amendment petition? They are saying this petition is saying.
That is the amendment application?
Yes, your lordship. Kindly come to the amendment application. That's very important.
Page 45.
Yes.
Page 45. My lord, 45A is the typed copy. It is a typed copy.
44, starting from page 44.
Now, your lordship, kindly come main thing. That is the topo shield.
Yes.
Kindly come to topo shield. My lord, প্রথম দফা বাদী রাজি তৃতীয় দফা শেষ বসিবে নিম্ন তপশিল বঞ্চিত such and such you have written. Thereafter, my lord, the next page, fair 47A. My lord, kindly come Krishna Chandra Manna, middle portion. Lordship got it?
Yes.
Krishna Chandra Manna ke 3 কেতা দলিল মূল নালিশি সম্পত্তি তার 3 পুত্র দান করেন। সেই 3 কেতা দলিলের কোথাও কোনো ডিড প্ল্যান নাই, অর্থাৎ কৃষ্ণচন্দ্র মান্নার দ্বারা সম্পাদিত ও রেজিস্ট্রিকৃত দলিল হইতে সুস্পষ্ট প্রতীয়মান হইতেছে যে নালিশি সম্পত্তি বাসুদেব মান্না, অনিল মান্না এবং রঞ্জিত মান্না, this অনিল মান্না is the father of the petitioner, মধ্যে যৌথভাবে অবস্থায় রহিয়াছে, অর্থাৎ নালিশি সম্পত্তি উপরোক্ত 3 কর্তার মধ্যে পাঠিয়ে। নাও your lordship, kindly see the next part. অর্থাৎ পশ্চিমবঙ্গ ভূমি সংস্কার আইন এর 14 ধারা অনুসারে কৃষ্ণচন্দ্র মান্না 3 পত্রের মধ্যে বিভাগ বন্টন দলিল বা ডিক্রি হয় নাই। ভেরি ট্রু, ইট হ্যাজ নট বিন ডান। মানে দেয়ার আফটার তৎকারণ পরবর্তীকালে অনিল কুমার মান্না স্ত্রী ও কন্যা নালিশি সম্পত্তিতে তাহাদের অবিভক্ত যে অংশ 2016 সালে সালে সাচানসাস দাগ নাম্বার দানপত্র দলিল মূলে অত্র মোকদ্দমার বাদী অনুকূলে দান করেন, সেই দানপত্র দলিলে সংযুক্ত নকশার কোনো আইনগত মূল্য নাই, যাহা শুধুমাত্র নালিশি সম্পত্তি অবস্থা।
Amendment application, while disposing of an amendment application, how the merits of the case
No,
can be
it
gone
is,
into?
it is not the merit, because your lordship, this is this is the part of the toposhil. My lord, kindly, why this order, my lord? My lord, may I say, in the disguise of an amendment petition, my lord, where he says that a portion which has been acquired by the PWD from the suit property during the time of his predecessor, my lord, that has not been mentioned in the the suit. And your lordship, but that is a part and parcel of the deed of gift which his father received from his father. But my lord, the difficulty is
yes, please show me where is the infirmity? Where is the infirmity?
The main thing is that this page, kindly see page 48, দ্বিতীয় দফা।
Yes.
This line এর মধ্যে PWD দ্বারা অধিকৃত 4 শতক বাদে বস্ত্রী 8 শতক
if this line is not considered maybe is not amended, this is a partition suit, Lordship. The share of the parties, it will be defective, Lordship.
No, by amendment, what is the case which you want to make out by way of an amendment? You have tried to make out a new case. by way
Yes,
of amendment.
Lordship.
How can that be
Yes.
done?
Yes.
Lordship, if this line, if this 4 shatak of land, description of the 4 shatak of land, and it is not considered.
This longish amendment, you have tried to make out a new case.
Yes.
How can that be done by
Yes.
way of an amendment?
Yes.
Lordship, that is in the paragraph. Lordship, main thing is that Ditiyo Dafa, that is Ditiyo Dafa page.
All right, come tomorrow.
Not paragraph, it is in the schedule.
Yes,
The main line, Lordship.
Had the learned advocates. Opposition is not necessary. Yes, call the next matter. Yes.
My 151.
একটা তিনটে, একটা চারটে, আর একটা ছিল।
151 application was rejected, my lord. My lord, this is the suit for injunction, my lord. My lord,
What has been rejected?
151 application, my lord.
For
my lord, the injunction, my lord. Because my lord, it is
151 for injunction.
yes, my lord. Because my lord, it is a leasehold property, my lord. The petitioner plaintiff is the son. My lord, the defendant is the defendant number 1 is the father, my lord. My lord, it is a leasehold property, my lord.
No, 151 is for what?
For not to take.
Where is the 151 application? Please show me.
Application is not annexed, my lord. So, my lord, your lordship can.
What is the prayer in 151?
Kindly see the order, my lord. Kindly see the order, my lord. That was mentioned, my lord. My lord, kindly see the last page, my lord. It is the order, my lord. Order dated, my lord, 4th July 2026, my lord. My lord, they have, my lord, the added respondent. I add, my lord, because, my lord, during that pendency of the suit, my lord, the father sold the
Injunction application has been was fixed for hearing on 1st of August.
No, my lord, kindly see, my lord, the application 151 dated, my lord, rejected. The injunction application is pending since 2000. Accordingly,
No, there is already an order of injunction pending. Why have you filed another 151 for injunction?
Because, my lord, kindly see the one order, my lord, addition of party, my lord, during the pendency of the suit, my lord, the father, my lord, transfer the leasehold property, my lord.
Yes.
I filed an application for addition of party that was allowed. My lord, the second defendant, my lord, tried to, my lord, demolish the, my lord, building, my lord. So file an application, my lord, for protect the property, my lord, for protect the property, not to demolish, my lord.
That's injunction. That has to be order 39 rule 1 and 2. If rejected, and it's an appellable order. And more so, the injunction application has been fixed for hearing.
The 151, they have rejected, my lord.
The 151 rejected. If it is a form of injunction, it's an appellable order. Even if it is a captioned as 151. Or 150 temporary injunction is fixed for hearing. I'm directing the temporary injunction to be disposed of when it is fixed for hearing.
Kindly see the fair hearing, my lord, on 1st August 2026. My lord, that was already over, my lord. Date was over, my lord.
What is the next date fixed?
Kindly allow me tomorrow, my lord.
By the order
Lordship, this is an application for expeditious disposal of the title suit number 125 of 2026.
What is the stage of that suit?
Lordship, if it comes to Lordship, page number 6, Lordship, there is a tabular formation. Lordship, the suit was instituted on March 2026. Thereafter, Lordship, along with an application for injunction, Lordship. That injunction application has not been heard.
Order 7, Rule 11 disposed of?
No, Lordship.
Is pending?
Lordship. Lordship.
What is the next date fixed for hearing of that?
Lordship, the next date fixed for Order 7 is on 3rd September, Lordship.
3rd
But
September.
Lordship, injunction application has not been heard by the
This application under Article 227 of the Constitution of India is at the instance of the plaintiffs praying for a direction upon the learned civil judge senior division first court at Kontai, district Purva Medinipur to dispose of title suit number 125 of 2026 expeditiously.
Along with
First
the
of the
injunction
learned advocate appearing for the petitioner submits that several interlocutory applications, one under Order 7 Rule 11 of the Code of Civil Procedure filed by the defendants opposite parties, and the application under Order 39 Rule 1 and 2 of the Code of Civil Procedure filed by the petitioners are pending. The learned advocate submits that the application under Order 7 Rule 11 of the Code of Civil Procedure is fixed for hearing on 3rd of September 2026. First up, in view of the order sought and proposed to be passed next, in the light of the submissions made by the learned advocate for the petitioner, CO number such and such stands disposed of by requesting the learned civil judge, senior division, first court at Kontai, to take up the hearing of the application under Order 7 Rule 11 of the Code of Civil Procedure on the next date fixed, that is on 3rd of September 2026, if the same is otherwise ready for hearing, and make an endeavor to dispose of the same as expeditiously as possible, without granting any unnecessary adjournments to either of the parties. First of the learned trial judge is also requested to make an endeavor to dispose of the application under Order 39.
Lordship, and the suit, Lordship, may be included, Lordship, the expeditious.
First, let these applications be disposed of. Yes.
For rejection, the petition order 18 Rule 17, my lord.
For?
Rejection of my application order 18 Rule 17. No opportunity was given to cross-examination of the witness, my lord. If I can turn to page 30 of the petition.
Yes, similar application was rejected on 28th of...
Not similar, my lord. Earlier, I filed the application for recalling the order, my lord.
What recalling? Where is the order dated 28th of August 2025?
Kindly turn to page 30 first. Page 30. Plaintiff file Hadra. Learned advocate for plaintiff is present, defendant is absent. In this matter, last line. Learned advocate for plaintiff stated he has no other.
Yes, to cross-examine the witness.
Yeah.
So this application was rejected. Where is the order dated 28th of August 2025?
That is annexed, that is already at page, my lord. 34, my lord.
Yes.
I filed this application for recalling the order, my lord.
You did not challenge this order.
I did not challenge, but that not proper form, my lord. That petition was not proper form.
Not in proper form. It was rejected on merits.
Merits was there, but not proper, but the state is not made in under Order 18 Rule 17, my lord. That was rejected. Accordingly, then I made the application under Order 18 17. The defendant party are entitled to cross-examine the witness either side, my lord. From this beginning.
So your evidence has been concluded.
My evidence is closed, my lord.
Asun, this application under Article
32, this matter may be released because your lordship had the occasion to appear for the petition, my lord. Here's the order.
32 Tata. Since I'm not inclined. Call the fixed matter. Yes.
But I'm led by Mr. Aniruddha Chatterjee in this matter for the petitioner. That due to some medical emergency, he had to rush to the hospital. He was in court in the first half. He's, my lord, directed me to request your lordship to, my lord, adjourn it for one day. We've informed the other sides. Both are present. I was beseeching your lordship to kindly take it up anytime, my lord. Tomorrow, my lord, anytime.
Tomorrow matters are fixed. It's difficult. Fixed matters, if you...
I understand, my lord.
Tomorrow, so entire week from 3 p.m. matters are fixed.
Lordship is keeping it next week. There's only one submission, my lord. Now, the interim order that your lordship had passed, my lord, that is till the 27th, which is why he asked me to request your lordship to keep it, my lord, tomorrow. If it's not, my lord, if it doesn't commence to your lordship to take it up this week, may that only be extended, my lord. This was regarding that physical possession.
What was the interim order passed?
Lord, Mr.
We have
Kaur,
giv-
your lordship
we
will
have-
remember.
We have given
Yes, they had given an undertaking.
undertaking. And on the last occasion also, my lord, when the matter was fixed, they did not even appear.
No, we appeared.
No,
we
my lord,
appeared
on the
in the
last
matter.
occasion, when it was fixed at 3:30, they did not appear. On the last occasion, Mr. Kaur extended his.
No, we appeared after that. We appeared after. The matter was there for extension of interim order. I was, Mr. Chatterjee, lordship will recall, Mr. Surojit Nath Mitra was there for the other opposite party. Mr. Kaur was also, Mr. Chatterjee was also here, my lord, on the last occasion. Lordship was pleased to extend that
An
undertaking.
earlier date before that, my lord. I'm not standing in the since Mr. Chatterjee has some medical emergency, but my lord, kindly appreciate my situation as well, my lord.
What can be done? Now, that's up to you. Matters.
No, lordship, that only because it's an emergency, my lord, I'm making that
I
submission.
appreciate, but
My fault. It's my fault, my lord. I completely concede that, my
it's
lord.
difficult to again fix because all matters from 3:30 on all days I'm fixing these matters.
Maybe come back anytime next week, my lord, or in the month of September.
Then 28th, Friday, 3:30.
Yes, my lord.
28. Yes.
No, 3:30.
Yes, yes.
Be here. I'll be here, subject to that.
But my
I'll be here, my lord. I'll be here. I don't have. Mr. Chatterjee also, I convinced Mr. Chatterjee to also be here. Well, I don't have any difficulty.
there are every chances that there will be
Only because
there
of
will
that.
be every chances that there will be a resolution. So far Friday is concerned, my lord.
So if there's
Otherwise, I'm not
resolution,
standing in
if
the way.
both of you appear, there's no
I'll
problem.
appear. I'll appear, my lord.
Yes, if all of you appear, no
I'll
problem.
appear.
Ashun. Chatterjee. Call the list. 33, yes, who is appearing? Yes.
Madam, I am praying for expeditious disposal of ejectment execution case.
Ejectment execution case.
Petitioner filed the eviction suit, my lord, and that was decreed. After that, he filed the execution case, where the JDR appeared and one miscase has been filed. There is no stay. Well,
how many miscases are pending?
Only one single. One miscase. Order 9, Rule 13.
Order 9, Rule 13 pending.
Pending, my lord. And my lord.
No stay.
No stay. Kindly come to the page 55, my lord.
So in the execution, no miscase is pending.
No execution. Come to the page 65, my lord.
Page 65.
65. First of all, page 63, my lord. First, second. On 18th 125, my lord, the order portion. Today is fixed for the hearing of the petitioner for stay and hearing petition dated 7/8/7/24. Both parties file Hazira through advocate. DHR file supplementary affidavit.
Miscase 69 of 2024 is for Order 9 Rule 13.
Yes, my lord. After that, verbal stay has been heard out, but no order has been passed. And it is continuing. Last order was on 16th 5/2026, my lord. But no order has been passed.
What is the clarification sought for?
My lord?
What is the clarification sought for?
Court clarified that
is directed to serve a copy of
Because my application for expeditious disposal of a matrimonial proceeding, Lord. Lord, I am the husband, Lord, it's my suit. Lord, it was filed in 2021. Lord, one miscase was filed by my wife, which was filed in 2023.
miscase for alimony.
Alimony pendent.
Yes.
Lord, affidavit with respect to the miscase is complete. My suit, the wife.
Evidence in miscase is complete.
No, but the affidavit assets are yet to be filed. But the written objection has been filed. In the suit, the written statement has also been filed. The issue has not been framed yet in the suit. Now the application is pending as well as the suit. At present, as in the last orders, the judge in charge is there.
This application under Article 227 of
Number 35, this is my application for expeditious disposal of a
Expeditious disposal of
a title suit, Lordship 749 of 2022, currently pending.
what is the stage of the suit?
Lordship, the suit was filed in the year 2022. Thereafter, WS was filed in the year 2024. Thereafter, petitioner, being the plaintiff, missed one day, and the next date was fixed for show cause. The show cause application was filed on 5th.
Application under Article 227.
Since Your Lordship, Ms. Bhattacharya is appearing for the
Since I'm not inclined to take up this matter.
I am appearing on behalf of the petitioner. It is the expeditious disposal of the suit and application.
The Banerjee is appearing. Thank you. Yes,
My lord,
yes.
but in this matter, my lord, there is a 4 application is pending. The suit is going on the instance of the plaintiff number 2, who is nobody in the suit, my lord. But the plaintiff number 1 withdraw him to the suit, but it was rejected on the ground that plaintiff number 2 is not willing to giving the consent. For such reason, it is going on, my lord. And 2023, the pleading is completed in the injunction application. Till date, the injunction application is not disposed of. And the other application, I am
22 Rule 2, that has to be a hard fast. 25th of September.
yes, my lord, the 3
Injunction application is pending.
pending.
What is the other application pending?
Other application, my lord, I am filed at recalling of the injunction which was given. That
Order 39 Rule 4.
not order 39, insufficient court fee. On the ground of insufficient court fee, I am filed the recalling application which is attached to this petition, my lord. That is also pending. Written objection also filed on that application also.
What is the date fixed for hearing of those applications?
Next
No date has been fixed. Only Order 22 Rule 2 has been
yes,
fixed.
fixed, my lord.
This application under Article 227 of the matter?
Your Lordship, kindly, the 8 weeks maybe.
Yes, yes.
Last time your Lordship directed to dispose of the matter within 8 weeks. Well,
Next date.
8 weeks is the order 22 rule 2.
Meeting from the next date.
Yes.
Two further months.
8 weeks, because next date is 23rd of September. 4 weeks is holiday, Mr. Banerjee.
In this matter, Ms. Bhattacharya is appearing.
Since I'm not inclined to take up this matter.
Is my petition, my lord. Suit for declaration, injunction, and recovery of possession. In that suit, the suit is decreed, first appeal preferred, first appeal dismissed, no second appeal preferred. I am the judgment debtor. In the execution proceedings, I filed Section 47 application on certain grounds, as well as Order 21, Rule 97, 101.
How it is maintained in Order 21, Rule 97 at the instance of the judgment debtor? Again, a title will be decided afresh.
Now, learned trial court conjoins both the application and the maintainability petition filed by the decree holder. In that maintainability petition, both the applications had been dismissed.
Rightly. What remains?
Because,
nothing.
my lord, in
Order 21, Rule 97 is not maintainable at the instance of the judgment debtor.
Section 47 application.
What is the ground in Section 47?
Section 47, one of the ground which challenges the executability of the decree.
What is the ground of
contends
executability?
That the decree has been obtained from certain areas which is not in possession of the judgment debtor, rather is in possession of the municipality of Bankura municipality.
All right. You are not affected.
Lordship, kindly sees the 47 application.
Yes, yes.
Lordship,
Who are you? What is the suit filed?
My lord.
What is the suit for?
Suit for declaration, injunction, recovery of possession. I actually, certain things has happened in which the judgment debtor could not contest at all.
How many order 47, Section 47 you have filed?
This is the only one.
Only one.
Till date, only one. And now the point is,
others are in the queue.
I am in possession of the property since 1947.
Remain possession till it is executed.
Lordship, kindly sees paragraph 6 or page 22.
Paragraph 6 of page 22. What is there?
That is the point in which the decretal property is
has not been sufficiently described.
Sufficiently not only not sufficiently described, rather it is a possession of the third party, the state.
You are not affected. So you will not be evicted from there.
So, but the point
you will not be evicted from there. You are not affected. Let the state come in. Let the state come in.
Kindly allows me to serve and come back. Kindly allows me to serve and come back.
What? This application? Yes, yes. This application under Article
Inconsistent with alert plot number 2616 has been described as Rasta. A decree has been passed on this.
Uh,
So that is the inexecutability part of the decree.
you are not affected by, you are not on Rasta. You are not on Rasta.
That is the that means in 47 also commission can be held.
Full stop paragraph.
When
The
this
petitioner
point
is the
has been
judgment
raised.
debtor.
For the item number 40, I'm availing on behalf of the defendant petitioner.
Yes, what is this matter?
That a suit for partition and permanent injunction was filed, my lord, before the learned court below. My lord, in the year of
Expeditious disposal.
Yes, my
What is the stage of the suit?
lord. Here in the matter is
Order
in the
1 Rule 10
stage,
2
my lord.
application is pending.
No, my lord. I need to take yes, my lord.
This
Order on
application under Article 220.
Not for the item number 41, I beg to appear on behalf of the petitioner. In this matter is also same, my lord. The expeditious disposal.
What do you want?
My lord, the probate suit is pending before.
Expeditious disposal.
Yes, SRET has been completed, my lord. For the written statement, the several adjournment was pleased. Several adjournment was passed, my lord, by the learned court below. Your lordship kindly sees the order.
This application under Article 2
42, my lord, I'm appealing for the petitioner.
Opposite party number 4. Who is opposite party number 4? Yes, Mr. Chatterjee, what is this?
This is, my lord, what happened, my lord.
Please use the microphone.
What
Adjust.
happened, my lord, I am the person occupier. My lord, there was an order, my lord, of demolition the building, my lord. This Honorable High Court permitted the occupiers to go for appeal in, my lord, before the tribunal. Now, my lord, what I transfer from the series of records, my lord, is that initial, when the persons came to this Honorable High Court, this Honorable High Court of prima facie view, because the impugned order, my lord, of demolition goes on the basis that there is no plan. My lord, we have produced the plan before the court at the time of hearing before the Honorable Court. Now, my lord, the tribunal also, my lord, at the time of, my lord, passing the order, kindly turns to, my lord, page.
For hearing of the stay application, it is paid.
Yes. Now, my lord, this appeal, my lord, what happened, my lord, got dismissed for default. Now, my lord, that's exactly, my lord, kindly turns to, my lord, page 47, 29th of November 2023. Now, my lord, we filed a restoration much belatedly. Now, my lord, during the pendency of that restoration application, we were served with a notice, you vacate. My lord, we immediately approached this Honorable High Court in writ jurisdiction. This Honorable High Court said that you go to tribunal and press before the hearing of the restoration application and the stay, which is also pending there. Now, my lord, we went to the tribunal, impressed upon the learned tribunal that kindly takes up my restoration and the stay as well. My lord, the last order which is passed is on 19th August, where the tribunal has directed me to complete the service upon private respondent number 4. He is represented now. Now, my lord, and fix the hearing for stay and the, my lord,
31st of August.
Now, my lord, in the meantime, their notice is already served, and my lord, I am being threatened every day to vacate, and otherwise they will demolish the entire building, where I am carrying on the plan with me, which is with me. And my lord, this Honorable High Court in earlier occasion holds that yes, there is a plan. And my lord, the tribunal, he says no, my lord, that exactly what has happened.
Yes.
Before the hearing, before the special officer, my lord, I was not there. My lord, I could not produce, they did not produce the plan. My lord, this is the plan with me.
You have
Of
got
the
a copy
building.
of that?
No.
The civil division application?
No.
Please serve me a copy.
Yes, that I can.
Please serve the corporation also. I am directing the what will be done before 31st. It demolished.
This is 7 days given time, my lord.
When?
To
From when?
My lord, 6th August. My lord, I am being just lingering, my lord, with my persuasive value. My lord, nothing more.
Persuade for some more days.
My lord, that persuasion may be recorded, my lord. I may persuade. My lord, persuasion has a limit. Persuasion has a limit, my lord. I am exhausting my limit.
Before the tribunal, it is fixed on 31st of August.
I will satisfy. May I get a copy? I will satisfy everything.
All right, please serve a copy.
Well.
Please serve upon the corporation also.
Well, in the meantime, for 2 to 3 days,
What
if
in
they
the
come,
meantime?
if they come, my lord, then my lord, I will be in a trouble. Because I am with a plan. The entire order of the tribunal records from the record, there is no
Petitioner
plan.
is directed to serve a copy of
Other matters are released. I'm opposing this application. I have a point of maintainability.
So here, my lord, what happened, section 36 application has been dismissed. My lord, preliminary award has been passed for dissolution of a partnership firm. While, as on the previous occasion, Mr. Chaudhary has indicated, I'm led by him, he's, till the time he comes, my lord, allow me to proceed. What has happened here was that there were talks of settlement going on. Then, because of, my lord, section 29 in the learned arbitrator, my lord, wanted the hearing to happen, but then because of the talks of settlement, my lord,
Permit, Mr. Chaudhary.
Yes.
2 points. Number one.
What is the order under challenge? Which order is
Milord,
under challenge?
Order refusing stay under section 36 on totally wrong premise.
What is the order dated?
7th August.
Yes.
Milord, may I just, in 5 minutes, take your lordship through the whole thing? 2 points, Milord. One is the award itself is infructuous. Reason is, Milord, 2015, my learned friend's client retired from the firm. 2022, the firm was reconstituted and it got converted into a company. He's my brother. So between 15 to 20.
Why are you fighting with your brother, Mr. Chaudhary?
Milord, to keep lawyers alive. We tried for a settlement. I'm told in principle it was worked out. Now for a settlement of this nature, there has to be assessment by income tax, Milord, consultants, etc., etc. That was being done. The learned judge, Milord, at that point of time said, no more time. You have to finish. And that's why the award, and that's why I'm before your lordship. Milord, if the learned judge at that point of time had not passed the order directing, Milord, closure of proceedings, it would have been settled by now. But this is the grievance. And that's all. And I'll show the minutes. It's very clear from the minutes. I have total respect for the learned judge. If I'm sent back, Milord, ultimately my 34 succeeds, I'll happily go back. In my 34, I have personally put in a paragraph saying we have complete respect for the learned judge. I'll actually happily go back to the learned judge, because if there is time, his lordship will hear me and his lordship will change his mind. But, Milord, the resultant, Milord, award, preliminary award is, Milord, totally, Milord, wrong. And ignoring things on record which would not have been ignored if we had been allowed to make submissions. Milord, so 15, he goes out, my wife comes in, part of a larger oral family settlement where, Milord, we transfer properties, etc. 15 to 22, for this firm, me and my wife, the new partner, Milord, we sign accounts, everything. He's nowhere to be seen between 15 and 22. 22, me and my wife, we convert this company, this firm into a company under the Companies Act. Then the firm is no longer in existence. Then I continue. Then one fine day, when disputes arise again, he goes back on the family settlement and he says, my resignation without a written letter is wrong, so reopen everything. In the section 9, he gets an ex parte order, learned arbitrator is appointed, and, Milord, it goes to arbitration. 9 becomes a 17, matter is argued, order passed by the learned arbitrator saying, I have no jurisdiction over the company. If his lordship has no jurisdiction over the company, and the firm has got converted into a company in 22, in 25, what is the point in directing accounts of the firm to be taken? There is no firm. By statute, it's become a company. So, Milord, I ask for a stay. This is one ground. Milord, may I just show your lordship, Milord, page 63, volume 1.
Please place the impugned order. Let me go
Yes.
to the impugned order there.
Page 137, Milord, volume 1.
Yes.
It's, Milord, with respect to the learned judge, Milord, it is replete with, Milord, error. Milord, I won't place the submissions.
Yes.
Milord, please come to page 5. Milord, 5 is also submission, I'm sorry. Page 6. Milord,
yes.
Third paragraph. Before going into further, it is to submit that while considering the instant miscase on ex parte, this court in the order dated 19th February
somehow considered the award impugned and came to a finding as enumerated therein. However, from the facts of the instant case, it appears that the instant arbitral dispute arose out of a partnership firm being SK Bhagat and Company under a reconstituted partnership deed dated 1st April 2006, whereby the parties before this court were partners of the firm and had equal shares in the profit and loss of the firm. Such firm was dissolved by the respondent by way of a letter dated 22, wherein further requests were made by the respondent for finalization of accounts of the partnership firm and for distribution of the assets. The partnership deed dated 2006 contained an arbitration clause. Then, my lord, pursuant to invocation, matter was referred to arbitrator. Then the award. Then please see, my lord, page 7, fourth para. In the order dated 2nd August 2023, the learned arbitral tribunal held that after hearing learned advocates of the parties and going through the averments made in the statement of claim, it appears that so far prayer H is concerned, that is declaration that the formation of the company SKBC Properties is illegal, null and void, the said issue cannot be decided in this arbitration proceeding, as SKBC was or is not a party to the agreement. This is His Lordship's own order, which possibly was not noticed at the time His Lordship may not pass the preliminary award. Then, may not please come to the rest of it. But in the award dated such and such, learned arbitral tribunal held that the respondent had proved that by notice under section 43, the firm was dissolved with effect from 10th November 22. 21st October, it became a company. The firm was not in existence. It was not in existence. Then, next page, my lord, impugned award speaks. Parties before arbitral forum made their substantial argument. Now, please note this. I'll show, my lord, from the minutes. There is zero argument. Four issues framed.
Yes.
Then, my lord, last paragraph, petitioner had made submissions on limitation. Then next page, in view of the above, it is found that parties to the arbitral reference were given opportunity of hearing. Therefore, on the ground of without being given opportunity by the learned tribunal, petitioner should not get any order of stay, which is an interim award for protecting rights. This is the mistake again. This is not an interim order for protecting rights of the parties during pendency. This is finally directing, my lord, status of the firm, of a non-existent firm. Totally erroneous, my lord. I'll show the award. My lord, please see, my lord, page 1171. Please see para 40 and 41 of 1171. And if your lordship is reading the impugned order, my lord, please see the next part, which says 36(3) unconditional stay. Is not possible. 36(3) proviso is only for money decree. It has no application. So the two grounds, my lord, that interim order is for interim protection and, my lord, 36(3) proviso, both have no application. Totally wrong. Preposterous, my lord, to contend that the impugned order is for protecting rights. I don't remember my learned friend arguing this, my lord. If he did, my lord, it's not correct. If he did not, then the learned judge should not have held this. He's not even getting angry these days.
Yes.
Now, my lord, please have a look at, my lord, just a few documents, my lord, 10 minutes. Please see, my lord, page 63. What? My lord, please have a look at section 366. My lord, this is the URC1 document.
So this miscase is section 34 has been disposed of.
36.
36 has been rejected.
So, but here it says, therefore, in view of the above, this court deems it fit and proper to hold that the preliminary award does not call for any interference.
At a 36 stage. At a 36 stage. At a 36 stage.
No, it's all wrong. Every sentence is wrong.
Says the preliminary award does not call for interference. That will be under 34.
That will be under 34. But it is at a 36 stage.
Yes.
Because the application is under 36.
Stage, virtually the 34 has been decided.
No.
That's the finding.
No, my lord will kindly see. My lord, the first paragraph. My lord will kindly read the first paragraph. First paragraph.
Entirely wrong.
Praying for stay of the preliminary award. This is the application which the learned judge was dealing with.
Not every sentence is a contradiction.
Your lordship can say that 34 will be open for them. It is open. 34 is still pending.
Yes.
And we will go back before the learned arbitrator.
And that is
to appoint a receiver to a commissioner of accounts to take accounts of firm which is not legally and factually in existence. This is the problem. Now, my lord, please, my lord, take page 63. I'll be very brief, my lord. 21st October 22 is the date of this document. Under, my lord, the section which I've handed up, my lord, section 366.
Yes.
A firm can become under Companies Act a company. It's a statutory conversion. My lord, please see the section 366. For the purposes of this part, the word company includes any partnership, firm, limited liability partnership, cooperative society, etc. And my lord, this provides for my lord conversion. Then my lord, please turn over and come to my lord section 368. When the firm is converted into a company, all properties will not statutorily vest in the company. It's a statutory vesting. That's Milord 368.
But Mr. Chaudhary, these are on merits of
No,
the
just
award.
to show that this is an infructuous award. Milord, please see.
Can that be said at this stage?
At least,
because
Milord, till this question is decided, he should not go back to the arbitrator and proceed and try to get a final award.
That's exactly the point.
Now, Milord,
Stay of the arbitration proceedings.
now this is statutorily.
Where is your application under section 36? Please show me that.
Milord, may I just show two things before that? Just two things. I'll come back to it. Page 1313 is my application. Milord,
131.
1313.
1313.
Volume 10.
What are the documents you have annexed, Mr. Chaudhary?
Milord, we've annexed everything so that, Milord, at least most.
And few fabricated documents. A police station which did not exist.
Forget about
reference of that
Volume
year.
10, volume 10 page 1313.
Lord, we asked for stay. We never got a chance to, Milord, just, I'll, after your lordship sees, Milord, and prayer is at 1364. Lord, prayer is 1364. We asked for stay.
Please show me the award. Where is the award?
Yes, my lord. My lord, 1126. And my lord, please see, my lord, 1171, which is the, my lord,
1171,
volume 9.
Volume 9.
Volume 9. My lord, these are the directions, paragraph 40, and the award is paragraph 41. All happening for a firm which does not exist. 1171, my lord. My lord, please see, my lord, paragraph 40 towards the middle.
Yes.
The claimant and the respondent number 1, last, my lord, 7-8 lines, are directed to amicably settle the accounts of the dissolved partnership firm. So his retirement is held to be bad and his notice of dissolution is held to be good. So this firm has allegedly now stood dissolved. Within 1 month from the date of passing of this preliminary award, in default, the parties would be at liberty to apply for appointment of a commissioner for settlement of accounts in terms of Order 26, Rule 11, and pray for final decree on settlement of accounts. Then paragraph 41, he's been granted, my lord, an award of injunction. 3 injunctions. And now everything, my lord, relates to a firm which is not in existence.
What is the finding with regard to this formation of the company?
My lord, that is there in the interim order. I showed your lordship. My lord, please have a look at the interim order.
In the final, in the preliminary award, where is that?
My lord, subject to correction, not noticed. Hey, hold on. No, not noticed. It is there in the interim order. Because when section 17 was moved, I took the point that company is not a party. So how can you get an order relating to the company? That is when the learned arbitrator rendered this finding.
Question of formation of the company not considered.
Can't be considered by interim order, my lord. I'll just show your lordship the order.
Yes, Mr. Bhattacharya.
Let him make his submissions. I will, my lord, find first of all kindly comes to
and whether this formation of the company
yes,
has
my
been
lord
dealt with in
said
the
I will not get into this question. He kept it open.
Where
He
is that?
said
Where is that?
That's in the interim order.
That's in the section 70. But before that,
Page
your lordship,
1046.
In the preliminary award.
not in the preliminary award. Not in the preliminary award. He said I need not get into this.
All right.
But not in the award.
Yes.
Page 1046, my lord. The order starts at page 1043, volume 8.
One zero
43.
104.
Volume 8.
Volume 8.
Lord will kindly take paragraph 39 of the award at 117. That is
Paragraph 39.
39 at 1170.
1170.
Yes.
That is a limitation.
No. I'll just read it out.
Very well. Please see the interim order first, then I'll take your lordship through 1170.
Yes, 1 minute, Mr. Chaudhary.
At least till
Except-
2022, it was there.
Yes, paragraph 39 quoted the interim order. That's all.
Yes, Mr. Chaudhary, which page you are saying, volume 8?
1043. That's below where the order was passed, volume 8. 1043. This is below second sitting on 2nd August 23.
Yes.
Now, my lord, 1044, paragraph 2. It asks for, my lord, dismissal. There, my lord, please see 1045, prayer age of his statement of claim, which, my lord, the learned arbitrator says can't be gone into.
Declaration that the formation of the company is null and void.
Yes. Now, what is this company? This firm has become the company under the Companies Act. And then, my lord, see what the learned arbitrator says at paragraph 4, at, my lord, 1046. After hearing learned advocates of the parties, it appears that so far prayer H is concerned, that is declaration that formation of the company SKBC is illegal, null and void, said issue cannot be decided in this arbitration proceeding, as SKBC Properties was or is not a party to the arbitration agreement. Moreover, question whether formation of a company under Companies Act 2013 is illegal or null or void is not an arbitrable issue. But once this happens, firm has become a company under statute. All its properties are vested under 368 under statute. There is no existence of the firm. The reference is infructuous. Now I'm going to argue this at final hearing. Now please see what happens at the final hearing. Not just 4 pages. First is, my lord, 2 dates, and I won't, my lord, disturb your lordship with details. 20th November 23 to 3rd August 24, which is, my lord, a period of almost 8 months. Both of us lead evidence. Both brothers come to give evidence, and, my lord, to prove loss of that partnership deed, I bring 2-3 more witnesses. Subsequently, my lord, a preliminary issue was framed for 2 sessions for decision. Now, please see, my lord, page 1001. This is volume 8. Question was, my lord,
This is not a 34 stage. My learned
why are
friend
you
is
getting anxious?
going on with facts. Then I will also argue on facts.
My lord, this is the question. 2 sessions are framed morning, afternoon. He argues in the morning, or I argue in the morning. But by mid-afternoon, we agree that matter should be settled. My lord, 1001 is morning session. 1003 is afternoon session.
Chaudhary, only one thing. Now the issue is whether the rejection of your prayer for stay was right or wrong.
Yes.
So that is only to be
The
tested.
prima facie case I am only showing.
34
I
is
never
also
got a-
pending.
Yes.
34 is also pending. So now
Every
this
finding-
order, whether stay should be granted or not, that is only to be considered.
Just 2 more things, my lord. So, my lord, we decided that we will settle the matter. This is August. Next date was, my lord, fixed on in November, on 7th of November. Now, my lord, 7th, where is that chart? I'm sorry, my lord,
But the settlement failed.
My lord, please come to 1005. Settlement didn't fail.
No, settlement has failed.
1 minute.
Settlement has failed.
Don't get apprehensive. 1005.
Yes.
My lord, these are the adjournment prayers. Now, my lord, from November, both of us were asking for adjournment because settlement was ripe. All this is happening. Ultimately, my lord sees page 1013. Please come to 1013. First of 2nd of January, Lordship, my lord, decides that no, I am not going to allow. Parties wanted adjournment, but Lordship says that no, I will not allow.
Yes.
Kindly take 1013. Oh, I'm sorry, no, this is a request for adjournment, and my lord,
That
the minutes, my lord,
this
I'll
is
show.
for 2024.
Yes. Now, my lord, so preliminary argument, my lord, we did on that one point, agreed for settlement. On 2nd January, Lordship says that no. Oh, yes, my lord, I've got the page. 1111. Please, my lord, take 1111.
Yes.
On the last sitting held on 29 September, on the question of preliminary point, etc., parties had concluded submissions. Thereafter, parties by email, 1112, my lord, 4th line, parties by email repeatedly prayed for adjournment for the purpose of effecting settlement. Ultimately, by email dated 24th November, this tribunal directed the parties to take final decision by 22nd December. It was ordered that in default, the tribunal fix 2nd January for further argument as last chance. Parties thereafter jointly prayed for further adjournment for the purpose of effecting compromise with a request to fix a date in the month of February. Since mandate of this tribunal is going to expire on 3rd March 25, this tribunal is not prepared to accept the suggestion given by the parties and wants to pass order on the question. My lord, both of us asked for adjournment. Learned judge said that because my mandate will expire, I will not. Now, my lord, please come back to 11005. My lord, please come back to, Lordship is seeing that.
Mr. Chaudhary, these are the points
Sir,
which have
just
to
to
be
complete.
argued in section 34.
Yes, my lord. But
So how
after
can
this, I
this-
never got a chance to argue.
So this is the
So I have so 2 points. Prima facie.
34. Those are the grounds in 34.
Yes.
You may succeed in 34, but now the issue is I'm not
Be
deciding.
left, my lord.
I'm not deciding the 34.
Right, my lord.
So now is the question whether stay should be granted
Now, my
or
lord,
not.
please come back to the order impugned.
Yes.
Please come back to the order impugned. Now, I've given your lordship the background. Just see, my lord, the order impugned. 3 or 4 reasons. I'll deal with each of them.
Yes.
Please come to first, my lord. Please come to paragraph 40.
Yes.
Hare, no, give me the impugned order. I'm sorry, my lord. My mistake. Impugned order, my lord. Page 6.
Yes. Yes.
My lord, page 6, my lord, I'll make it very brief. Background is noted in the last 2 paragraphs. Then, my lord, page 7, 3rd paragraph. In the proceeding, petitioners paid for stay of award mostly on account of settlement. Then the order is, my lord, set out. That order which says nothing with SKBC. Now, if the learned court below had seen this order, then the learned court below would be quite certain that nothing can affect the right of the company by reason of the arbitral proceeding. But the direction in the award is para 40 and 41 accounts of a non-existent firm. So, my lord, that's why, my lord, a stay. Because it's an infructuous order and he is doing, my lord, witch hunting before the tribunal against me.
Yes.
Now,
yes,
next,
Lord,
my lord.
Anything more?
Yes, 2 crowns, my lord.
Yes.
Next, my lord. Paragraph, page 7, last 4 lines.
Yes.
On perusal, it is found that midway of an ongoing arbitral process, aforesaid order will not be prejudicial and not affected by fraud or corruption. Such direction merely declares the rights of parties. It does not. It also directs appointment of commissioner. So that's a very serious error. It's not just a declaratory award. Next sentence. If such direction is not grounded, purpose of arbitral proceeding will be futile. Again wrong. Lord, the award is not, my lord, appreciated by the learned court below. And then, my lord, on the next page, natural justice and findings at page 9, that I was given opportunity to make submission, that I was, my lord, heard on the merits, substantial arguments is the recording of the learned judge. Totally wrong. And lastly, my lord, the learned judge, this is specifically on the ground of stay. Page 9, second paragraph, proviso to 36(3). That only applies to money awards. My lord, please see, my lord, the proviso. That is only for money claim.
Yes.
Lordship has seen, my lord, provided
Yes.
explanation, my lord, makes it very clear. It's for money claims. Otherwise, there's no question of, my lord, deposit of money. Condition is only for money claims. My lord, so, my lord, to prevent, and he's not constantly holding, requesting for sittings for appointment of commissioner over a non-existent firm, he's proceeding in arbitration.
Yes. Yes, Mr. Wadekar.
First, to dispel your lordships.
Page 1, 2, 3, 4 is his application before the learned arbitrator.
It is most unfortunate that Mr. Chaudhary has made the submissions that the learned arbitrator prevented him from making arguments. Because 28th, 29th, 30th sittings, he has made arguments which is recorded. My lord will kindly look at this. My lord will kindly look at the 1139 onwards. Making aspersions against the learned arbitrator, my lord, it is not proper.
Then I want to place the minutes which I was placing.
Yes. My lord will kindly look at 28th sitting.
1:15 on a working day, on a mobile phone saying, do you have anything to say on limitation?
My lord will kindly look at this.
My lord, please, my lord, just give me 2 more minutes.
Finish, Mr.
Let me
Chaudhary.
show the next 4. My lord, your lordship, stop me.
So, Chaudhary, I will give you time. Let me hear. Yes.
My lord will kindly see 28th sitting.
Yes.
Learned advocate for the respondent to make submissions on the question of limitation, the plea which has been taken in the first paragraph of statement of defense. Accordingly, Mr. Chaudhary, with such and such appearing, has made submissions on the question of limitation and concluded the same. Then, my lord, next sittings.
Yes.
Then finally, at the 31st sitting, which is at page 1147, it starts the minutes of the meeting. 1147, at page 1148, paragraph 3.
Yes.
Be that as it may, after pronouncement of the order of refusal of adjournment, Mr. Chaudhary, learned senior counsel, appearing on behalf of the respondent, submits on instruction from his client that in the event the prayer for adjournment is refused, he has been instructed not to argue any further because that will destabilize the proposed settlement. So he was instructed not to argue. Now, my lord, so far as this conversion to company is concerned,
yes,
my lord, both at section 11 stage, we had filed a section 9. My lord, that order of the commercial court, your lordship will find, starts at page 676. Volume 5, 676. I will just take 2 minutes, my lord.
76, volume 5.
Yes. Paragraph 11.
Continue tomorrow. my lord.
No.
Quarter to 5.
You have continued for 45 minutes. I will just take 5 minutes, my lord. I will just take 5 minutes.
670.
5 at 687. This is of the Learned Commercial Code. Because you're not
87.
Paragraph 11 at 687. Because I have a time constraint.
Yes.
My lord will kindly look at I do not admit the proposition of the Learned Counsel for the respondent. Paragraph 11. Because your lordship will kindly see that section 369. He had shown 366 to 368. He did not show 369. Any allegations with regard to erroneous incorporation of the company or wrongful mutation, such and such, but I cannot accept the argument of Learned Counsel that the interim order has been passed against third party in the present proceedings, which is not tenable in law. As section 369, your lordship has the Companies Act, your lordship will kindly look at section 369. Provides that where a partnership firm has been converted into a company, it does not affect the rights and liabilities in respect of any debt or obligation incurred.
Yes.
Same was the view of the section 11 court, which is at paragraph 24 of that judgment. I will show, my lord, at page 697. 697, my lord.
697. Which volume?
Volume 6.
Volume 6.
It starts at 691 at 697.
Yes.
It is settled law. Page
Yes.
697, paragraph 24. It is settled law that the beneficiary of a wrong is bound by its consequences. If it is ultimately held on adjudication that the petitioner is entitled to share of the assets in the partnership firm, the mere incorporation of a company with such assets cannot absolve the parties from their liability as partners. Now, my lord, what is he trying to do today? This 36(2) is filed with the intent to stall the arbitration proceedings. There is not an award which I can enforce. Is it an enforceable award? Can I enforce it? No. My lord, Supreme Court has now said, has categorically said, my lord, this is 2026 3 SCC 264. One paragraph I will just show. That courts should not stall arbitration proceedings. My lord, paragraph 27. Delhi High Court. The above provisions make it clear that the Arbitration and Conciliation Act embodies the legislative
Paragraph
policy.
27.
27, my lord.
Which page?
My lord, it would be page 38.
Yes.
The above provision makes it clear that the Arbitration and Conciliation Act embodies a legislative policy of party autonomy, limited judicial interference, and procedural self-sufficiency. Section 5 expressly restricts judicial interference, except as provided under the Act, which is, in this case, 37. There is no appeal against this order. Act, reflecting the pro-arbitration intent of the legislature. One, the parties have agreed to resolve the disputes to arbitration, and such agreement satisfies the requirements of Section 7. The court role becomes largely facilitative, confining to enabling, not obstructing the arbitral process. So today he's trying, and then, my lord, paragraph 39.
Yes.
Thus, the entire scheme of the Act strongly discourages any midway judicial intervention, especially by way of review, as it would run contrary to both the text and spirit of the statute. Well, apart from...
Only one thing, Mr. Bhattacharya, there's an preliminary award pass.
Yes, madam.
So that has been challenged under section 34.
34 and 36. 34, yes.
34, that has been challenged.
Yes, madam.
And during the pendency of that section 34, a stay has been sought for that the arbitration further proceeding should not be done.
Stay of execution of the award, not the stay of arbitration proceedings.
No, stay of execution of the award. So what is the preliminary award? So for finalizing the accounts and the things.
It says afterwise it would be the last paragraph.
Now that has been challenged. Let us suppose if it is set aside in 34. So this will be an infructuous exercise which is to be done.
My lord will kindly look at section 16. My lord, that is for the arbitral tribunal to decide. If finally, my lord, I tell your lordship what is his apprehension.
Now section 34 is maintainable against this challenge to the
Yes,
preliminary award.
yes, I do not.
So if that is maintainable, so against that, the directions contained in the preliminary award, if that is continued
But
and
it
that
is
is
not,
enforced,
34
what
has not
remains
been
then?
34 has not been taken up. We don't know which way it will go.
Yes,
not interested in
section
doing it.
34 has not been taken up.
My lord, what is he saying?
During the pendency of the section 34, if that is not stayed and the accounts and other things, those are done, what would happen then?
Final award. He can challenge the final award as well.
What will be the final award?
Final award would be for accounts. He can challenge it.
Yes,
It
so
will merge into it.
So why at this stage the commissioner will prepare the account?
Well, God knows how many years it takes for the 34 to be decided.
That cannot be a ground.
Well,
But
there
that
is no
cannot be a
stay.
ground.
Well, do
Then
I
there is
have
no-
a decree?
Then there is no use of this section 34.
Well, do I have a decree which I can execute? Moreover, apart from this judgment which I have shown, my lord, there is a further bar under section 8 of the Commercial Courts Act. My lord, will kindly look at section 8 of the Commercial Courts Act.
Yes.
Apart from bar under section 5, no revision is also maintainable. I am not for a moment saying that 227 is not maintainable. Under 36, there can be a stay of execution. But there cannot be a stay of arbitration.
That's not in the scheme of the act.
That is not in the scheme of the act.
Not a question of arbitration. Only the directions contained in the preliminary award.
Well, that would be putting a spanner on the arbitration proceedings.
So, if the section 34 is
No,
ultimately
that cannot
allowed,
that cannot
what
be
would
done under the garb of
will it
section
not be
36.
an infructuous thing, exercise being done?
That's exactly the scheme of the act, and that's why they have made, introduced 29A and all to make it time bound.
That's there. It's a time-bound procedure that's there. Now, one thing, since an award, preliminary award has been challenged in 34. So during the pendency of the 34, if the directions, those are executed or implemented, what remains in section 34 then?
There is no execution. There is no execution. Your lordship makes it clear that I will not execute that part of the award, but the arbitration proceedings will not be stalled.
All right. When can you come back?
My lord, I can come back tomorrow. Day after is the learned arbitrator has kept it.
Tomorrow, I think matters have been fixed. কালকে আছে না? Up to 28th, it's fixed.
No, I will not, my lord. Even the learned arbitrator on the last day was very unhappy with their conduct. And one breath he is saying, I will go back before the same arbitrator, and he is opposing the section 29. Of course.
No, that's another thing. Then I have to stay the further proceedings of the arbitration till it is heard.
My lord will kindly not.
Otherwise, it's an. I'm hearing this better.
My lord kindly keeps it on any day convenient to your lordship.
Yes, that is cannot be done in this week. On all days, the matters are fixed. It has to go in
My
the
lord,
next week.
then in that case, my lord doesn't pass an order, I will consent to the adjournment.
No, you were.
I will consent to the adjournment. I will consent to.
Hard
So Saraf, submitted last chance, the time of 1 week can maybe given by which his client will bring necessary order of state from the honorable court. In view of such threat, tribunal fixes the matter on 26th on virtual court.
Now he says that he will, now he's, yes. Acha, then both of you jointly pray for an adjournment. I think that would be better. First piece of submission. Yes.
One matter, my lord, the
This
urgency.
is not the mentioning time, madam. Yes. Mr. Chaudhary, please take back.
My lord. He didn't hand over. It's my book.
Now, can you do one thing, either of you, the stay application, only the preliminary award, the stay application, the impugned order, I think section 17 order you want to rely upon.
And those minutes.
How many minutes?
It says 5 or 6.
Those relevant minutes. So make a compilation of
May I also hand up a list of dates.
yes, list of dates you can hand up. Please bring those documents in a compilation. It's very difficult to go through
If it can be
1200,
kept on,
1500 pages.
if it can be kept on record, the list
It's
of dates.
only 20 to 30 pages which is relevant.
Yes, yes.
For that you have filed 1500 pages of civil
Because
petition.
we're all apprehensive of him.
So these are the applications which are, please make a compilation of that.
Yes. And I'll give it to my learned.
Yes,
secretary.
if Mr. Chaudhary makes a compilation, please
I'll do it, my lord. I'll do it well within time.